pretty sure that we're okay on our end, but we're just waiting for the go ahead for it to get the green light. So just hang tight there, guys. We still don't have the green light quite yet, but while we're waiting, I would recommend to the jurors and participants alike, it's more important for the jurors, I think, to go in the bottom left hand corner. First of all, the mute button should always be checked, and the stop video should always be checked. But furthermore, there's a little caret next to the stop video button, and you can go into the video settings, and you can check hide non-video participants. So then you're not going to see a little black box for the people who are constantly muted, like the other jurors, and more of your screen will be able to be taken up by the advocates, which I think is nice, but it's not necessary as long as I have it on mine, the YouTube stream will look correct. and also advocates, until we actually get started, you guys can turn off your video cameras for right now if you want to. It's up to you, but I realize you probably are trying to look professional, and you probably don't have to until we're actually started. So Okay, looks like we have the all clear to start. So let's take a moment for the competitors to start their videos back up. Okay, that looks like everybody. Good afternoon. Now that we have everybody here, I think we can get started. Let's call the case of State of West Carolina versus Timothy Ray to order. My name is Judge Sperber. As I said earlier, scoring judges, make sure that you keep your audio and video turned off throughout the entire course of the trial. And to the extent, if you haven't already figured out how to hide all non-video participants in the video settings, I think it's helpful, although it's not necessary, but it will allow you to see more of the competitors and less of people who aren't talking. With that, I think I'm ready for appearances.
Good afternoon, Your Honor. My name is Surgeon Aurora, and alongside my co-counsel,
Haley Naughton.
we represent the state of West Carolina in today's case.
Okay, good afternoon. How about the defense?
Good afternoon, Your Honor. My name is Alexandra McCormick, and I, along with my co-counsel,
Graham Marcus,
represent the defendant, Mr. Timothy Ray, in this matter.
All right, sounds good. Before we begin with your housekeeping matters, I do have one of my own. I think we all appreciate that we're doing this over Zoom, and I don't think we need to have any, pretend language as if there's a well or there's anybody to approach. So I think it's easier to just do away with any of that sort of thing. Also, I anticipate that on housekeeping, we're going to have some sort of conversation about objections and what's within and without the earshot of the jury. The way I would like to do it is to have non-speaking objections first. So meaning you can state your objection, say objection, Your Honor, whatever the objection is. And then you can trust my constructive ability to mute the jury at that point. So we don't have to have a constructive sidebar or anything else like that. As long as you don't launch into your argument, I will be constructively able to mute the jury, and thus those arguments are not going to be heard by them. So we can do away with all that awkwardness. Okay, that's all I have. So let's hear some housekeeping from you guys.
Your Honor, may we have standing permission to share our screen with opposing counsel, the witness, and the bench?
Sure. Okay, so I know I just made that whole thing about what the jury can hear. I think technically we don't want to share anything that's not in evidence yet. That's as it's coming into evidence. So as I believe the rules state, to the extent that something you need to show for identification purposes or to opposing counsel or the witness an exhibit that you intend to enter into evidence, let's just refer to a page number in the electronic file. And then from there, once it's in evidence, absolutely feel free to share your screens. Or if you guys stipulated to something already, then that's all right too.
Yes, Your Honor. And Your Honor, may we presume all witnesses have been constructively sworn in?
Yes.
And finally, Your Honor, the state has two motions in limine in today's case.
Okay, first, let's see if the defense has housekeeping matters.
Yes, Your Honor, we do. We actually have a couple. It is our understanding that the federal rules of evidence and federal rules of criminal procedure apply in this proceeding. Accordingly, pursuant to Federal Rule of Evidence 615, we would ask the court to invoke the rule of sequestration and have all witnesses, with the exception of the defendant, as well as the expert witnesses, constructively sequestered from the courtroom at this time.
Okay, any objection from the people?
No objection, Your Honor.
Okay.
Your Honor, we would also like to inform the court that all defense exhibits are pre-marked and with the clerk constructively.
Okay.
That would be all. We do have two pretrial motions to take up with the court as well.
Okay, so we're gonna hear the substantive motions from the people first, but I thought of two more issues I'd like to deal with now rather than later. As I think maybe some of you have seen, because of the Zoom format, sometimes objections go unnoticed. So I would just urge the competitors to, as forcefully as you can, make an objection. And if it's not heard and the testimony is continuing, keep saying it until either I notice or the witness stops speaking, because we don't want things coming out that should be objected to. But the audio is weird that way. So, we are all in that understanding. I also am under the impression that there isn't actually going to be a defendant on an individual tile, but I presume the state is going to, need to at least constructively identify the defendant. Does the defense have any objection to stipulating to the fact that the state has identified the defendant, and we can do away with that as well?
No objection to that, Your Honor.
Okay, super. That should cover everything I can think of. All right, people, let's hear your substantive motions.
Yes, Your Honor. So our first one is actually regarding 615. That's already been addressed. So we'll move on to your second one. Your Honor, today we're seeking to bar the defense expert's third and fourth opinion. Now, today the state has charged the defendant with first-degree murder. The defendant has filed notice of insanity, and per pretrial order, this cannot be revoked. Now, this jurisdiction dictates that in order to prove insanity, the defense must show that the defendant was unable to appreciate the wrongfulness of his acts. And in an attempt to do so, the defense has retained Major Riley. Major Riley in his report explicitly mentions that the defendant did not have the ability to understand the wrongfulness of his actions. And even more so, Your Honor, Major Riley contends that the defendant did not have malice aforethought nor premeditation. Now, pursuant to this jurisdiction's case law, Pasquarello v. West Carolina, in a case where the defendant makes insanity his defense, those ultimate issues regarding whether the defendant knew right from wrong are for the trier of fact alone, pursuant to Rule 704B. And accordingly, Your Honor, the state moves to bar any mention of those ultimate issues.
Okay, defense.
Your Honor, there is no objection. We understand that that would be improper under Rule 704, and it would go to the ultimate issue, and therefore we will not be eliciting that testimony today. We would ask that the same ruling, though, be held for the state.
Okay, and people, do you object to it applying equally to you as well?
No, of course not, Your Honor.
Okay, so granted on consent, there won't be any testimony that violates the Pasquarello rule regarding expert opinions insofar as they go to whether or not the defendant had the ability to understand the consequences of actions. All right, anything else?
No, Your Honor, with that, the state is ready to proceed.
Okay, let's hear from the defense.
Your Honor, calling your attention to page 4 of the case packet, item 6 of your pretrial order, we understand that there was a previous motion to suppress that was denied based on constitutional grounds. At this time, we would be asking to exclude any and all evidence of the interview between the defendant and Detective Booth pursuant to Federal Rules of Evidence 1002, the best evidence rule. As Your Honor heard during the pretrial hearing, Detective Booth said that he stated he was never put on notice and that the defendant's mental state was not going to be an issue, which was his reason for not preserving the recorded interview. During this interview, Mr. Ray began to show symptoms of schizophrenia, a fact at issue in today's trial. This interview was subsequently recorded and transcribed. At this time, Mr. Ray began to ask the detective whether he was with the CIA. At that point, Detective Booth was put on notice to preserve that recording, and he had 30 days in order to do so. Ultimately, not requesting a copy of the video took evidence away from our expert witnesses to evaluate, as the video would have shown the demeanor of the defendant and would have aided in their evaluation. For that reason, we are asking to exclude any and all evidence of that transcription.
Just a clarification question before I give it over to the state. So there's obviously a physical transcript that's within the case packet. Is your objection, are you moving to preclude specifically that transcript as a document, or are you trying to preclude testimony regarding the interview as it was actually a fact that occurred?
Yes, Your Honor, we would object to excluding the document.
Okay. People?
Your Honor, in today's case, Detective Booth got the chance to sit down with the defendant, and he interviewed the defendant, and accordingly, this transcript was written. Your Honor, simply because the detective chose not to record it doesn't go to the testimony, doesn't go to this evidence, it doesn't go to its admissibility, rather its weight. That's something opposing counsel can bring up on cross.
Okay, defense, I'll give you the last word on this.
Your Honor, we would rely on our previous argument. The Detective Booth acted in bad faith when he did not preserve that recording, and for that reason, we would ask for it to be excluded.
Okay, motion denied. That being said, it hasn't been entered into evidence yet, so if the state intends to enter the document into evidence, we'll have to go through the process at that time.
Understood.
Anything else?
Yes, pursuant to Federal Rules of Evidence 801 hearsay, we are asking to exclude Exhibit 10. Your Honor, these are phone searches that were found on the defendant's phone. While pursuant to Stipulation 1, we stipulated that these are authentic phone searches. We are objecting to them as hearsay, as the state cannot lay a proper foundation that they are an admission by party opponent, because they cannot prove that it was the defendant himself who made those phone searches.
Okay, people?
Yes, Your Honor. Now, if allowed to testify, Detective Booth will tell us that he confiscated this phone throughout the course of his investigation. It remained in police custody, and the police had the phone until it was sent for a forensic investigation. And the forensic investigation of this phone that belongs to the defendant was stipulated to, Your Honor. Just because this, again, Your Honor, goes to the weight of the actual evidence, not its actual admissibility.
Yeah, I tend to agree. Motion denied.
Understood, Your Honor. That is all.
Okay. With that, then I think we'll move on to opening statements.
The defendant admits he killed Nathan Ray. Let me repeat that. The defendant in this case admits that he killed Nathan Ray, his own and only child. October 17th, 2018 started out like any other typical morning for 6-year-old Nathan Ray. But little did he know this morning was about to take a turn for the worst. He's eating breakfast at the defendant's house when he accidentally spills juice on the defendant's laptop, which is unfortunate, but that's life with a child. You expect a parent to be mad, but understanding, upset, but consoling. And ultimately, that a parent would take this as an opportunity to teach their child that silly mistakes happen. But the defendant did the exact opposite. The defendant is angry. He's furious at his son. So he begins to scream at Nathan. And like any normal 6-year-old, Nathan's terrified and starts crying. He runs to his room, hoping for a safe place, but the defendant follows. The defendant storms into Nathan's room with the intent on punishing his son. The defendant decides to punish Nathan by first making him do jumping jacks and high knees. But this only makes Nathan more upset. He cries for his mom, hoping she'll come and save him. And he cries that he hates his dad, hoping he'll stop the punishment. Hearing this, though, further enrages the defendant, so the punishment only gets worse. The defendant leaves the room, giving Nathan a moment of hope that the worst is now over. But the defendant returns to Nathan's room with a belt. The defendant starts to beat Nathan with that belt, striking him over and over again, while Nathan screams and cries for his dad to please stop hurting him. And the defendant does stop, but only long enough to wrap the belt around Nathan's neck. The belt tightens around the child's neck as he's fighting to loosen it. The belt just gets tighter and tighter, though, as he's grasping for air. Now the defendant uses all of his strength to tighten the belt until his child, Nathan Ray, is dead. It is our burden in today's case to prove to you, beyond a reasonable doubt, that the story you just heard is true. That Timothy Ray murdered his son, Nathan Ray. And today, we embrace that burden and will meet that burden. Here's how. You're going to hear from Detective Blake Booth, an officer of 23 years. Detective Booth is going to tell you about his investigation into Nathan's death. He's also going to tell you about all of the evidence that he found: 2 bottles of bleach, a bloody shovel, and a box of trash bags in the back of the defendant's car. Then, Detective Booth is going to tell you about where he found Nathan's body: in a park, in a shallow grave, stuffed into a trash bag. And finally, Detective Booth is going to tell you about his interview with the defendant and how the defendant admitted he got angry with his son, admitted he punished his son, and admitted that he murdered his son. Members of the jury, I'm going to say this one final time. The defendant admitted he killed his son. It is uncontested that everything I just told you is 100% factual. So why are we here? We are here today because even though the defendant admits he killed his son, he's alleging that he has a mental disorder called schizophrenia and is therefore innocent by reason of insanity. But as you'll hear today, that simply isn't true. The defendant is wholeheartedly sane. And the second witness we are going to hear from today is Dr. Legrecker, an experienced forensic psychiatrist. He's going to explain to us exactly why we know that. Dr. Legrecker will explain to us that the defendant did not suffer from any mental disorder, rather that the defendant is malingering, which is essentially making it up. Dr. Legrecker will first explain how malingering recurrently happens in criminal trials, especially in murder trials, when a defendant is trying to avoid punishment for their crime. Second, Dr. Legrecker will explain how there's absolutely zero legitimate evidence that the defendant actually suffers from schizophrenia. And finally, Dr. Legrecker will explain today that the defendant knew exactly what he was doing when he murdered his son, because the defendant tried to cover it up by hiding Nathan's body, evading police, and is now trying to evade the consequences of his own actions. Anger is not an excuse. Rage is not an excuse. You don't cry over spilled milk, and you don't murder a child over spilled juice. But that is exactly what the defendant did here. Nathan Ray's life was cut far too short due to the defendant's inhumane form of punishment. And now it's your turn to punish the defendant for what he has done. Find the defendant guilty for the murder of his son, Nathan Ray.
Thank you, counselor. To everybody, just real quick reminder to everybody who is not actually speaking right now. So only the two openers should be unmuted or have their videos on. So just to make sure everybody double checks that real quick. Okay, now let's hear from the defense.
May it please the court, counsel, members of the jury. Evidence, not emotion. That's what this case is about. You just heard a very emotional story from the prosecution detailing the horrible night that Timothy Ray took the life of his son and his actions after that tragic incident. But their story is based on emotion. And we ask you to pay attention to the evidence throughout this trial, because the evidence will show that Mr. Ray, in the years, months, and even days leading up to October 17th, 2018, was suffering from a severe mental illness. Mr. Ray was neglected and abused by his mother as a child, who was later found to be suffering from a severe mental illness and institutionalized. Mr. Ray has been seeing and hearing things since he was 10 years old. Yet, he suffered in silence, not telling anyone about what he was seeing or what he was hearing, because he was scared. Scared that he was going to be labeled crazy. Scared that he was going to be institutionalized like his mother. So you're going to hear that since he was 10 years old, he has continuously struggled with this mental illness. Yet, he attempted to live a normal life. He graduated with a bachelor's degree from Skelton University and shortly after enlisted in the military. But his ability to overcome this struggle didn't last long. And shortly after basic training, he was discharged from the military for mental health reasons. You're going to hear about his commanding officer who observed him having trouble with sleeping, having trouble with hallucinations, depressive thoughts, and even suicidal thoughts. But just like he was used to and he had done his entire life, he denied all these observations because all he could think about was the troubling fact of being labeled mentally ill, of being institutionalized. So he continued to struggle. He continued to hold on. and began working as a computer technician at a small company for the next 8 years. But you're going to hear about an incident, and the evidence is going to show that Mr. Ray physically attacked an employee. Now, an expert in forensic psychiatry is going to testify here today and tell you that that is a sign of schizophrenia. But even more, he was found crying uncontrollably, hysterically in his cubicle in the months leading up to October 17th, 2018. And as the months led up to that tragic night, he was all but losing that battle with his mental illness. His symptoms becoming more and more pronounced. You're going to hear about the hallucinations and the negative thoughts overcoming him in the weeks leading up to October 17th, 2018, as he became more isolated, as he lacked hygiene, and he even neglected to sleep. That on October 17th, 2018, when Nathan Ray spilled that juice on his computer, the voices finally won the battle, and they forced him to do something unimaginable. They forced him to take the life of his son. But that is what brought us here today, because he is still suffering from that severe mental illness. And it is your job to determine whether he is legally responsible for the unfortunate events on October 17th, 2018. The state has a burden today. They have the burden to prove beyond and to the exclusion of every reasonable doubt that this defendant is guilty of first-degree murder. And the evidence is going to show they're going to be unable to do that today. However, the prosecution is not the only party who entered the courtroom today with a burden. See, the defendant has pleaded not guilty by reason of insanity. And what this means that we must prove only by clear and convincing evidence that he did not appreciate the wrongfulness of his actions on that tragic night. But this case is about evidence, not emotion. And to prove this today, we were going to call 2 witnesses. First, you're going to hear from Officer Wentz, the police officer who stopped Mr. Ray at the sobriety checkpoint. Now, Officer Wentz has extensive training in interacting and recognizing mental illnesses, and he's going to sit here and tell you today that Mr. Ray was exhibiting extreme paranoia during the sobriety checkpoint, that he was frantically asking about the CIA multiple times throughout this encounter. She will also describe the physical observations that she made of Mr. Ray, how he looked disheveled, and how he's acting strange up to the point of doing jumping jacks in the middle of the road. But you're also going to hear from Major Shane Riley, an expert in the field of forensic psychiatry, who analyzed the symptoms manifested by Mr. Ray throughout his entire life. Major Riley will describe the signs associated with an individual who suffers from schizophrenia, and is going to sit here and testify to you today that Mr. Ray exhibited those signs from his hallucinations as he was 10 years old to the deterioration in his health in the weeks leading up to October 17th, 2018. Additionally, Major Riley is also going to testify to the negative effects that his childhood abuse and neglect had on his health and on Major Riley's subsequent opinion. Finally, they're also going to talk about the possibility of malingering and how, or what we call faking the symptoms, and how it's always a possibility and it could be present in trials, but the evidence will show that it is not present today. At the end of this trial, you're going to hear from my co-counsel, Alexandra McCormick, who's going to go over all the facts and testimony you've heard here today. But we ask you, focus on the evidence, not emotion. At the end of this trial, you're going to have to make a decision. And once you have analyzed all the testimony, all the facts, and once you get the full picture, we are confident that you are going to come to the conclusion that Mr. Ray should be found not guilty. A verdict not based on emotion, but on the evidence. Thank you.
Thank you, counsel. Okay, so for those of you who had it on speaker view, for the statements, I now recommend switching to gallery view so you can see more people all at once. It'll make things easier going forward. And with that, people, if you'd like to call any witnesses.
Yes, Your Honor. At this point, the state calls Detective Blake Booth to the stand.
Okay, Detective Booth, come on up.
May I proceed, Your Honor?
Yes.
Could you please introduce yourself to the members of the jury? stating your name and spelling the last for the record.
My name is Detective Blake Booth, Booth.
You mentioned you're a detective. Where do you work?
I work at the Skelton Police Department. I've been there for the past 23 years.
Detective Booth, walk us through the process of becoming a detective.
I started with an associate's degree in criminal justice. From there, I went on to the Skelton Police Academy, received basic training. Afterwards, I was assigned to the Gangs and Narcotics Unit of the Skelton Police Department. Afterwards, when I transitioned into my detective role, I was assigned to the Homicide Unit, where I've been for the past 3 years.
You mentioned you're in the Homicide Unit. How many cases have you investigated there?
I've investigated 12 cases. This is the 3rd case I'm the lead on.
I want to talk to you about this case in particular, Detective Booth. How did you first get involved?
On October 18th, 2018, I received a call from a concerned mother, Jessica Ray, who needed to file a missing persons report for her son, Nathan Ray. She told me that the last time Nathan Ray was seen was 2 days prior, and the defendant had been the last person to see her. So with that, we filed a missing persons report.
Now, Detective Ray, was Nathan ever found?
Yes, he was. He was found in Brandywine State Park in a trash bag in a shallow grave.
I want to talk to you about how you found Nathan. Can you walk the members of the jury through what happened?
Yes. On October 19, 2018, I received a call from Officer Wentz, and he told me that he found the defendant at a sobriety checkpoint in downtown Skelton. I went over and saw the defendant was restrained with handcuffs on the curbside.
You saw the defendant sitting there. Did you speak to him?
I approached the defendant and told him that we would be taking him to the station for questioning. He said he understood me and he would tell us everything.
When you spoke to the defendant, Detective Booth, was he rambling?
No.
Was he mumbling?
No.
Was he speaking coherently?
Absolutely.
So what did you do next?
Told Officer Wentz, take the defendant to the police station, and there I conducted an interview with him.
I want to talk to you about your interview with the defendant. Can you tell the members of the jury a little bit about it?
He told me he killed his son. He told me how and why he did it. He told me that on October 17, 2018, his son, Nathan, was drinking some juice during breakfast and spilled some of that juice on his work laptop. The defendant got really angry and started screaming at Nathan. He ran up to his bedroom, crying.
What did the defendant tell you happened next?
At that point, the defendant told me that he got even more mad and went upstairs to Nathan's bedroom and started forcing him to do exercises. But this only made matters worse.
What do you mean by that?
Nathan couldn't really do the exercises, and he kept getting more upset. Eventually, Nathan started crying and said he wanted his mother and hated the defendant. And that's when the defendant said he needed to punish the defendant in a different way.
The defendant said what? Can you repeat that one more time, Detective Booth?
My apologies. He said that he needed to punish Nathan in a different way.
Did he explain to you what he meant by punish Nathan in a different way?
Yes, he told me he went to his own bedroom, grabbed a belt, went back to Nathan's bedroom, and started beating Nathan with the belt. At that point, Nathan began crying even more and once again said that he hated the defendant.
Objection, Your Honor. Hearsay?
Response?
Hearsay as to Nathan's statements, Your Honor? Your Honor, pursuant to Rule 8032, these are excited utterance.
Your Honor, if I may.
Sure.
If they're not using them for the truth of the matter asserted, then that's one thing, and we'd be fine with that.
Are you using it for the truth of the matter asserted?
Yes, Your Honor, we are using this to show that Nathan hated the defendant. But Your Honor, this is coming in because these statements are made while Nathan is under the pressure of his dad beating him with a belt.
Your Honor, they didn't lay the correct and proper foundation to bring in these this excited utterance, as they said, and I believe it's a hearsay without exception.
Overruled.
Detective Booth, What did the defendant tell you happened after Nathan said, "I hate you"?
At that point, the defendant lost it, and he pulled the belt around Nathan's neck tightly until he strangled Nathan to death.
During your interview with the defendant, did you notice anything odd?
Well, he did ask me a few times whether I was in the CIA. He's spoken to third person occasionally, and he also told me that his wife had been the one to trick Nathan into spilling the juice.
Did any of these things that you just mentioned, did they impact your investigation?
Absolutely not. He told me when we first arrested him, he wanted to tell me everything, and he openly confessed to his crime.
Did the defendant ever tell you what he did after killing Nathan?
Yes, he told me he drove around with the body for a couple days before burying the body in a trash bag in Brandywine State Park.
Did you find Nathan's body?
Yes, we did. We took a group of officers and canine officers to the park, and that's where we found Nathan's body in a trash bag in this park.
What did you do next, Detective Booth?
I investigated 3 other items of interest from the defendant. First, we searched the defendant's car, where we found a bloody shovel, bleach, and black trash bags. Then we searched the defendant's house, where we found...
Your Honor. This is speculation. They don't have any foundation that this is blood on the shovel.
Mr. Aurora?
Your Honor, this is a detective. He's seen all the evidence, and up until this point, we know that all this evidence has been collected. He's not going into anyone's mindset. He's not speculating about what this substance actually is.
Mr. Aurora, could you give me basically specifically what he said about whether or not there was blood on the shovel?
Yes, Your Honor. So this witness said that from the defendant's car, he found a bloody shovel, bleach, and trash bags.
Mr. Marcus, is that your understanding of the answer that was given as well?
No, Your Honor. Our understanding is that he believed it to be blood, and it was never tested and conclusively found to be blood.
Okay. In any event, overruled.
Detective Booth, I'll ask you again. What did you find from the defendant's car?
I collected a bloody shovel, bottle of bleach, and several large trash bags.
Did you find anything else, any other piece of evidence in today's case?
And then I searched the defendant's house, where I found the juice on the countertop and the broken laptop, still with that juicy residue. Finally, I went to Nathan's bedroom and found the belt that Mr. Ray used to murder his son. And then afterwards, I was able to obtain the defendant's phone, and I looked up his internet search history and found 3 items of interest, namely countries that don't extradite for murder.
Your Honor, again, this is hearsay, and we're just going to renew our motion from our preliminary matters.
Okay, Mr. Aurora?
Your Honor, pursuant to your pretrial motion, these search histories, it goes to the weight of the evidence, not the admissibility of it.
I don't think that was my ruling, and correct me if I'm wrong, but I'm pretty sure it didn't go into evidence. I just didn't preclude it at that time. We still need to see the proper foundation having been laid. I know that there's a certain amount of stipulated to, right? So as to, based on that stipulation, have you laid the proper foundation, Mr. Aurora, for these to come in?
Yes, Your Honor, I believe I have. I believe this witness has testified that this is done through the course of his investigation.
Okay, Mr. Marcus, considering the stipulation, do you have any further argument as to why this is an admissible hearsay?
Yes, Your Honor. Although we agree that it came from his phone, they cannot lay a proper foundation as to who made the searches. Therefore, it's not admission by a party opponent. There will be hearsay without exception.
Point well taken, but I do think that ultimately goes to weight, not admissibility, so overruled.
Detective Booth, what did you find from the defendant's phone?
I found his most recently searched items in his internet search history, which stated 1, countries that don't extradite for murder charges, 2, how to get rid of a body, and 3, bleach, destroy a body.
Your Honor, let the record reflect on directing the attention of opposing counsel to what has been previously marked as State's Exhibits 10, 18, 22, 26, 27, and 28.
Could I have some page numbers for those?
Yes, Your Honor. Give me 1 second. So page number, Exhibit 10 is on page number 57.
Okay.
Let me know when you're ready for the next one, Your Honor.
Yep, keep going.
Okay, Exhibit 18 is on page 95. Exhibit 22 is on page 99. Exhibit 22 is on page 104. And Exhibit 28 is on page 105.
Understood. Okay.
And let the record reflect I'm directing the witness's attention to what has been marked as State's Exhibits 10, 18, 22, 22, 26, 27, and 28. Detective Booth, do you have these documents in front of you?
I do.
You recognize them?
I do.
How do you recognize them?
These are photographs I took in the investigation of Nathan Ray's death.
And do these photographs truly and accurately depict those pieces of evidence as you last saw them?
They do.
Your Honor, at this time, prosecution moves State Exhibit Group 1 into evidence.
Mr. Marcus, any objections?
Can he just re-say what exhibit he's bringing into evidence? I'm a little confused.
Yeah, and so it's Group 1, which includes State's Exhibits 10, 18, 22, 26, 27, and 28.
Objection, Your Honor. First, cumulative evidence. Second, Your Honor, he has not laid the proper foundation to bring into evidence any of these exhibits.
Well, I think he's laid the foundation that they were pictures that he took, the officer took in the course of investigation, right? I mean, what more? Well, that's true of the pictures, and I think a fair amount of the foundation has been stipulated to in the case of the text messages. What further foundation do you think is lacking, Mr. Marcus?
Your Honor, first, he's inputting photos that we don't know that whether they're fair and accurate depiction, Your Honor. And second off, we're not, even if you agree that they can be entered into evidence under 403, its probative value substantially outweighed by its prejudicial effect as seen in Exhibit 27 in the room.
Okay, so I think that he did say that all the pictures were fair and accurate depictions of the scene as he saw it that day prior to taking the picture. As to the 403 argument for 27, you said?
Yes, Your Honor.
Okay, I will hear from Mr. Aurora on that issue.
Yes, Your Honor. The probative value of this is not substantially outweighed by any danger of unfair prejudice. Now, today, we, the state, have charged the defendant with first-degree murder, and the defendant is pursuing an insanity agreement, defense rather. And this evidence comes in to show that the defendant killed Nathan Ray, and these pieces of evidence, come in through Detective Booth's totality of his investigation. It goes to show that Detective Booth conducted a complete investigation.
Okay, Mr. Marcus.
Your Honor, if I may, there's no dispute here that the defendant did in fact kill his son. Therefore, we agree that he did kill his son and that this photo with the toy box and Nathan's name and the toys next to the belt is highly prejudicial and will only inflame the jury's emotions.
Is the prejudice unfair?
The prejudice is unfairly outweighs the probative value, Your Honor. And if I may, also with Exhibit 28 as well, the juice has no probative effect. It's a small cup, and therefore it will only inflame the jury's emotions, has no probative value in today's case.
Okay, so overruled on Exhibit 27. On Exhibit 28, briefly, Mr. Aurora, 403.
Your Honor, again, there's almost no unfair prejudice in the case of the spill of juice. Detective Booth is going to use this exhibit to tell the members of the jury that this spill of juice was found exactly where the defendant said it was. There's almost no unfair prejudice here, Your Honor.
Okay, overruled.
Your Honor, just to clarify, State's Exhibit Group 1 is in evidence.
Yes, so entered.
Permission to publish to the jury via screen share, Your Honor.
Granted.
Detective Booth, what can you tell us about Exhibit 10?
This is the photo of the internet search history. As you can see, the 3 searches that I mentioned prior are listed on Thursday, October 18th, and this is the phone belonging to Timothy Ray.
What can you tell us about Exhibit 18?
This is Nathan's body found in the shallow grave in Brandywine State Park, stuffed in a trash bag.
What about Exhibit 22?
This is the backseat of the defendant's car where we found items of interest, including a shovel, the bleach, and the trash bag.
And 27?
This is a room of Nathan's bedroom. This is a photo of Nathan's bedroom with the belt that the defendant used to murder Nathan on the floor.
And finally, 28, Detective.
This is a picture of the kitchen countertop where Nathan Ray spilled juice onto the defendant's laptop.
Now, Detective Booth, was there ever an autopsy done on Nathan's body?
There was.
Did you read that report?
I did.
Your Honor, let the record reflect I'm opposing counsel to what's been marked as Exhibit 6. Detective Booth, I'd like to direct your attention to Exhibit 6 as well. You recognize this document?
I do.
How do you recognize it?
This is the autopsy report that I requested from the coroner as part of my investigation.
And does it appear to be a true and accurate copy?
It is, yes.
Your Honor, at this time, the state moves to enter Exhibit 6 into evidence.
Any objections?
No, Your Honor, no objection per stipulation of the parties as seen on 4 and 5.
Super. It is so entered.
And permission to publish to the jury, Your Honor?
Granted.
Detective Booth, what does this autopsy report say caused Nathan's death?
The coroner determined that the cause of death was asphyxiation that was consistent with Mr. Ray wrapping a belt around the boy's neck, and the cause of death was ruled to be homicide.
Based off all this evidence, what did you do?
I charged Mr. Ray with the murder of his son, Nathan Ray.
No further questions at this time, Your Honor.
Okay. Cross.
Yes, Your Honor. May I inquire, Your Honor?
Yes.
Detective Booth, you've been an officer for about 23 years.
Yes,
And before working in the homicide department, you previously worked in the gang and narcotic related department, right?
that's correct.
And this case is the 12th homicide case you've investigated,
That's correct.
but you haven't led all 12 investigations, have you?
That's correct.
This is in fact your 4th time leading a homicide investigation.
That's correct.
Now, I want to walk you through the night that Mr. Ray confessed. You reported to a call that Mr. Ray was apprehended.
Yes.
You took him down to the station for questioning.
Officer Winstead, but yes,
And this interview was recorded.
it was.
You didn't observe any odd behavior during the interview.
No.
You knew Mr. Ray before that interview, didn't you?
Yes, I did.
You saw him frequently at your children's soccer games.
I did.
Objection or relevance?
Mr. Marcus?
Your Honor, I'm laying the foundation to show that the defendant was unable to recognize who Detective Booth was, and therefore goes to not only the ultimate issue in today's case, but also is relevant in an investigation.
Overruled.
Now, I'm going to ask that again. You saw him frequently at your children's soccer games, didn't you?
I did.
You talked with him.
I did.
He was socially awkward,
He was.
lacked hygiene.
Yes, he did.
But during the interview, Mr. Ray was unable to remember who you were.
We had to remind him.
So, I mean, just for the court reporter, is that a yes?
Yes.
And you reminded him repeatedly of your position as a detective at Skeleton PD,
I did remind him.
but he asked you multiple times if you were CIA.
He asked me that.
But you didn't believe there to be any mental health issue.
Do I believe there's?
Relevance?
Sorry, I couldn't hear that, Your Honor.
I was just asking for your response.
Oh, my response is this is the ultimate issue of this case, whether he was suffering from schizophrenia, and therefore whether he believed there to be a mental health issue goes directly towards this and should be weighed by the jury, Your Honor.
If I may, Your Honor. Detective Booth is a detective. He's not a forensic scientist. He's not a psychologist. He's none of those science related people who can diagnose someone with schizophrenia. Therefore, what Detective Booth believes about the defendant's mental state and any insanity or lack thereof is irrelevant.
Your Honor, if I may.
Yes.
Your Honor, he's just stating his observations of the defendant. He's not stating any diagnosis of the defendant. He's not giving his opinion of whether he was suffering from a mental illness at that time. All he is giving is his observation based on the physical observations and the conduct and contact that he had with the defendant.
Well, I guess the question is, why is it relevant that he made an observation or a lay opinion, however you want to characterize it, that there were no mental health issues being shown by the defendant?
Your Honor, this is a fact at issue in today's case, and not to mention that it's a bad faith investigation, as we said in our preliminary motions, and this goes to that bad faith.
Okay, on the credibility of the investigation basis, I'll overrule.
Thank you. Now, I'm going to ask that again, Detective Booth. You do not believe there to be any mental health issues?
I can't attest to that.
Is that a yes or a no?
I can't attest to that. I'm a detective. I don't know it's mental health.
I mean, it's a simple yes or no question. Do you believe there to be a mental health issue or not?
I don't know if he has a mental health.
Asked and answered.
There was an objection. There was an objection asked and answered. I mean, I think that he's basically saying he can't answer with a yes or no, so I'll sustain.
Yeah. So Mr. Ray confesses.
He does.
And at the end of the interview, the recording stops.
It does.
And it's automatically saved.
Yes.
And you requested a transcript of the interview.
I did.
But not to the audio or video recording?
Well, it was preserved for some time.
But you did not request it, did you?
As you said, it automatically preserves.
So do you have it today?
I do not.
Now, you could have preserved a copy, couldn't you?
I could have.
But you didn't.
I did not.
Now, you complete an incident report, didn't you?
I did.
And as an officer, you're trained to you fill out these incident reports.
Yes.
They have to be accurate,
Yes.
complete,
Yes.
truthful,
Yes.
and thorough, because you might rely on them in your investigation or for the prosecution, right?
Yes.
Now, and you wrote this incident report as only a total of 8 lines. Is that right?
That's correct.
Now, you did not include any of your observations of Mr. Ray's behavior.
That he murdered his son.
That wasn't my question, Detective Booth. I'm just going to ask it again. You did not include any observations of Mr. Ray's behavior.
Well, killing the son is behavior, so I observed that.
Let me, it's a simple yes or no question. Now, you did not include your observations of Mr. Ray's behavior, not his actions.
I think behaviors are actions, so I did. Yes, I put my observations in there.
Now, you never mentioned anything about the CIA, did you?
I didn't put that in there.
You looked no further into Mr. Ray's mental condition after he confessed?
I did not.
You looked no further into Mr. Ray's mental condition after you heard from Officer Wentz?
Objection on irrelevance. Maybe.
No, let's hear from Mr. Marcus. Why is it relevant?
Why it's relevant, Your Honor?
Yes.
Your Honor, it's relevant because, again, this goes to his overall investigation and the credibility of his investigation. Additionally, it goes to his credibility. And this is a fact at issue in today's case, Your Honor.
Overruled.
Now, I'm going to ask that one more time. You look no further into Mr. Ray's mental condition after hearing from Officer Wentz.
That's not my job. I did not.
Now, you received mental health training,
Some. I did receive some, yes.
but you can't remember any specifics of that training, can you?
No, it's been some time.
Now, I just want to talk one more thing about, you heard on direct about his cell phone. You have no personal knowledge of the defendant ever typing into his phone those searches?
I did not observe him, no.
Moment to confer, Your Honor.
Absolutely.
No further questions this time, Your Honor.
All right. Any redirect?
Very briefly, Your Honor.
Okay.
Detective Booth, did you have any reason to believe that those search histories weren't made from the defendant?
I had no reason to believe that. This was the defendant's own phone, and consistent with the timing of these searches was October 18th. It's highly unlikely that anyone else was the one to type this into the phone.
And secondly, Detective Booth, opposing counsel asked you about the incident report and it only being a page. Was your interview with the defendant longer than a page?
Yes, I believe it was about 5 pages.
No further questions, Your Honor.
Okay. In that case, Detective Booth, you may step down or turn off your video, I guess. Any further witnesses from the state?
Yes, Your Honor. At this time, the prosecution calls Dr. Legrecker.
Okay. Let's see. We've got Dr. Legrecker here. So proceed when you're ready.
Please introduce yourself to the members of the jury by stating your full name and spelling your last.
Dr. Legrecker, Legreca.
What do you do for a living, Dr. Legrecker?
I'm the program director for West Carolina School of Medicine's Forensic Psychiatry Fellowship Program.
What is forensic psychiatry?
It's a subsection of psychiatry that focuses on the relationship between psychiatry and the legal system. Often we consult attorneys, law enforcement, and courts if we need to provide expert testimony.
Have you provided expert testimony in the past?
I have. I've been an expert witness in 7 criminal trials. 5 of those involved mental illnesses, including schizophrenia and generalized anxiety disorder.
Can you walk us through your educational background?
I received my bachelor's degree in chemistry at the University of Delaware in 1985. Afterwards, I earned my medical degree at the University of Pennsylvania. I went on to complete my residency in psychiatry at UCLA. I returned to the University of Pennsylvania to complete my fellowship in forensic psychiatry.
And where'd you work after completing your residency?
After completing my fellowship, from 1994 to 2017, I owned my own private practice. It was called Legrecker Psychiatric Associates in New Jersey.
What'd you focus on there?
I worked with a diverse population of patients, diagnosing and treating a wide variety of mental illness disorders. This included schizophrenia and generalized anxiety disorder.
Are you board certified in forensic psychiatry and neurology?
Yes, I am.
Now, how'd you first get involved with today's case?
I was retained by the state of West Carolina to provide an opinion regarding Mr. Timothy Ray's mental health on October 17, 2018, the day he killed Nathan Ray. I then created a report based on my findings.
Are your opinions based on sufficient facts and data?
Yes, they are. I was able to review all exhibits and materials in preparation for my report. Notably, I looked at Major Riley, the defense psychiatrist's report, which included interviews with Mr. Timothy Ray, along with close friends and family. I also looked at the statements made by all law enforcement, including statements made by Detective Booth, Officer Wentz, and Mr. Timothy Ray's statements during his interrogation by Officer Booth.
Are all your opinions the product of reliable principles and methods in the field of forensic psychiatry?
Of course.
Did you reliably apply those principles and methods to the facts of this case?
Yes, I did.
Dr. Legrecker, are all your opinions held to a reasonable degree of medical and psychiatric certainty?
Yes.
At this point, Your Honor, prosecution moves to tender Dr. Legrecker as an expert in the field of forensic psychiatry.
Okay, any objection from the defense?
Yes, Your Honor. May we approach?
Sure.
We would object to tendering this witness as an expert witness under the Federal Rules of Evidence 702, expert witness testimony. And at this point, we would ask to voir dire the witness outside the presence of the jury.
Okay. State, do you have any objection to them doing a voir dire?
Yes, or no objection to the voir dire.
All right. Considering the time constraints in this trial, I would ask the timekeepers count this time against the defense rather than the state. But other than that, yeah, good. You feel free to voir dire.
Your Honor, if we just may have a moment to confer to check the rules. Previously, we were not counted for time for voir dire questions. Or I'm sorry, for the objection part, but only for the voir dire questions.
Yes, that's what I'm saying. Okay. The voir dire questioning part should be counted against your time. As soon as you're done with your voir dire questioning and you're back into your speaking objection, at that point, the time should stop again.
Understood, Your Honor.
as long as there's no rule against it, as far as I know, there's not. I think that complies with the local rules. But if there's something you can point me to, then, feel free.
No, I just wanted to clarify. Thank you.
Fair enough.
May I inquire?
Yes.
Dr. Legrecker, you sold your practice back in 2017.
Correct.
Now you're treating patients just once a week?
Yes.
You previously stated you're a teacher now.
Yes.
You've been a psychiatrist, though, for about 26 years?
Correct.
And during that time, you've never been published in schizophrenia?
No, but I'm currently.
Your Honor, relevance.
Okay. Ms. McCormick, why is it relevant?
Your Honor, this goes to the qualifications of the expert, which is especially towards schizophrenia, which is a fact at issue in today's trial.
Yeah, I think it goes to weight, not admissibility overruled.
Dr. Legrecker, I'll ask again, you've never been published in schizophrenia?
No, because largely my career focused on treating patients, and only recently I've had the time to focus on research and academia.
You've also never been published in the field of psychiatry in general?
No, again, because I've been focused on treating patients.
You are currently working on a study, though, is that correct?
Yes, I am.
That study is on malingering?
It's on the likelihood of malingering.
Specifically when it comes to subjects facing punishment?
Yes,
You have not completed this study, though, have you?
I have not. We are in the process of collecting data.
You have not completed the data portion.
Correct.
Now, you have testified, though, before, is that correct?
Correct.
In 2 cases.
Yes.
Both of those cases were regarding dementia.
Correct.
You would agree that you've never testified in a case regarding schizophrenia?
Correct.
A moment to confer, Your Honor.
Sure.
Your Honor, pursuant to Federal Rules of Evidence 702 expert witness testimony, we would object to Dr. Legrecker being tendered as an expert witness in this trial. The prosecution has attempted to declare his expertise in forensic psychiatry. However, the witness just testified that they lack practical experience, only treating patients once a week. But most importantly, 702C requires the testimony to be a product of reliable principles and methods. The witness just testified that they've used this study to form their opinion, which has been unpublished, not field tested, nor peer reviewed. For this reason, we would request that this expert not be tendered as an expert in this trial.
Overruled. So he is so tendered as an expert in this field. You may proceed, Ms. Naughton.
Dr. Legrecker, you mentioned you were retained to provide opinions in this case. Did you come to any opinions?
Yes, I actually came to 3 opinions. The first opinion, Mr. Ray did not suffer from any severe mental disorder. This includes schizophrenia. My second opinion, Mr. Ray manifested signs consistent with malingering during his clinical interview with Major Riley. And my third opinion, hypothetically speaking, if someone were to suffer from schizophrenia in the highly unlikely circumstance and were not malingering, they still would be able to understand right from wrong.
Objection, Your Honor.
On what grounds?
Case law requires, and under 704B, that the witnesses not be able to testify to the ultimate issue in this case. Although the state has offered a hypothetical, it is the issue in today's trial. It is the ultimate issue in today's trial, and he just gave an ultimate opinion, which is not allowed.
Ms. Naughton?
Your Honor, Dr. Legrecker's opinion of whether or not someone with schizophrenia understands right from wrong is not going to the ultimate issue of this case of whether the defendant had schizophrenia and knew right from wrong.
I mean, is there a practical difference between him saying in one question that he does have schizophrenia, and that, he does or he doesn't have schizophrenia in one question, and then in the very next question saying schizophrenia means there's no, they wouldn't have, or they would know the consequences of their actions? I mean, through the transitive property almost, what is the practical difference between a hypothetical immediately after a diagnosis?
Your Honor, may I confer with co-counsel briefly? Your Honor, the defense has pursued an insanity defense, and they have to prove that he did not understand right from wrong. So it's sort of a hard concept to grasp, but we're just trying to give here an example of whether or not someone that had schizophrenia would understand the difference between what is right and what is wrong.
Your Honor, if I may be heard briefly.
Yes.
According to page 14 of the case packet, Pasquarello v. West Carolina, on issues based because of Rule 704B, no expert may testify to whether the characteristics of a disease would bring in right or wrong. This is the ultimate issue in today's case. The expert witness is not allowed to testify to a jury his ultimate opinion in that. He can testify as to whether or not he believed that Mr. Ray had schizophrenia, but he cannot testify as to whether at that moment he knew the difference between right and wrong, as the case law states in the case file packet.
Yeah, I am concerned about this testimony, not because, I mean, it's, you know, I'm concerned about the precedent. I'm concerned about the jury's ability to determine the difference between his hypothetical situation, where a hypothetical schizophrenic person necessarily able to know the consequences of their actions. I could see how you could build up to, with the proper foundation, a permissible opinion that doesn't violate Pasquarello. And therefore, I'm going to let you try to lay the foundation when you get to that point in your direct. But for now, I'm going to sustain the objection as to the reference that he just made to his third and final opinion. I'm going to strike that answer. And when we are approaching that portion of his testimony, if we could have a pause and we could have maybe an offer of proof of the way the testimony is going to go, and we can take it carefully, and it'll all be paused for time purposes because it'll be an objection. But yeah, all that to say, sustained for now. Let's take it up again as we go through the direct and the foundation is laid. Okay?
Yes, Your Honor. So I want to talk to you about your first opinion, that the defendant did not exhibit any signs or symptoms of schizophrenia. Can you tell us first, what is schizophrenia?
Sure. Schizophrenia is a neuropsychiatric disease, or in simpler terms, it's a brain disorder. Less than 1% of the world's population suffers from schizophrenia.
And how's a proper diagnosis made?
The proper diagnosis of schizophrenia is made using the DSM-5, which stands for the Diagnostic and Statistical Manual of Mental Disorders and Clinical Evaluation, which is what I used to look at for Mr. Ray's mental status.
So what factors did you actually look at in this case?
The two main factors I looked at in terms of schizophrenia include hallucinations and delusions or paranoia.
Okay, I want to start by going through these one at a time. First, what's a hallucination?
So hallucination in layman's terms includes hearing, seeing, feeling, smelling, or even tasting things that aren't real. For example, auditory hallucinations, the most common type of hallucination, involves hearing voices or sounds that have no physical source.
Is it your opinion that the defendant was suffering from hallucinations before October 17, 2018?
No, it is not.
Why not?
There's no evidence that Mr. Ray was suffering from hallucinations. There was one instance in 2010 while he was in the military, and his commanding officer, Officer Cruz, reported that he was having hallucinations. But during his complete psychiatric evaluation with Major Riley, Mr. Ray explicitly denied that he was having any hallucinations.
And what was the conclusion of Major Riley's psychiatric evaluation?
Major Riley diagnosed Mr. Ray with generalized anxiety disorder, and he was then discharged from the military.
Did the defendant see any other doctors after he was discharged?
Yes, Mr. Ray saw a family medicine physician, Dr. D Giuseppe, 3 times from 2010 to 2017.
Did the defendant ever tell Dr. D Giuseppe that he was having hallucinations?
No, Mr. Ray never reported he was having hallucinations to Dr. D Giuseppe.
Did the defendant tell anyone that he was having hallucinations?
No, according to all the reports, Mr. Ray didn't tell any of the individuals he interacted with most. His father, his wife at the time, his boss, none of them indicated that he had symptoms or observed any of these symptoms firsthand.
So when did the defendant report he was having these hallucinations?
The only time Mr. Ray reported or told anyone he had any hallucinations was to Major Riley after he was arrested. Even then, we don't know for sure whether the voices Mr. Ray is complaining about can even be considered hallucinations.
Why is that?
Like I mentioned before, the voices indicative of schizophrenia are perceived external sounds where the listener believes everyone else can hear these voices too. These can be contrasted with anxious or depressive thoughts that are more in line with your inner conscience. In this case, Mr. Ray alleges that he hears things which are really considered his own anxious and depressive thoughts, not hallucinations.
Okay, so you concluded that the defendant didn't suffer from hallucinations before October 17, 2018. So now I want to move on to the next factor that you mentioned, which is delusions or paranoia. So what are delusions or paranoia?
So delusions are beliefs that are not based on any absolute truths. Paranoia, in turn, is the feeling that you're being threatened in some way, or someone is watching you or acting against you, even though there's no proof for this to be true.
Did you find that the defendant suffered from delusions or paranoia before October 17, 2018?
No, there was no evidence of delusions or paranoia.
Can you elaborate on that?
Sure. So during the first two visits with Dr. D Giuseppe, Mr. Ray didn't report suffering from any delusions or paranoia.
What about the third visit?
During the third visit with Dr. D Giuseppe, Mr. Ray did mention that he was asking Dr. D Giuseppe if she was speaking with his wife behind his back.
Okay, so after learning about this, is it your opinion that the defendant was showing signs of paranoia or delusions?
Actually, not at all. You see, Mr. Ray was suspicious of his wife, and he had good reason to be. He had the belief that his wife might be having an affair, and it actually turned out to be true. She was having an affair with their neighbor. So this alleged paranoia isn't paranoia at all because it ended up being based on absolute truth. So in combination with this third visit and the first two visits, Mr. Ray didn't exhibit any symptoms of mental illness in terms of delusions or paranoia.
Did the defendant tell anyone that he was having delusions or paranoia?
Again, based off all the materials, Mr. Ray, with the people he interacted with the most, his father, his wife at the time, and his boss, none of them indicated that he was complaining of any delusions, nor did they see him suffer from delusions or paranoia.
So when did he first bring these up?
The first time he brought up the paranoia or delusions was during the clinical interview with Major Riley after the arrest for killing his son.
And after going through the defendant's history with hallucinations and delusions, do you believe the defendant was exhibiting any signs or symptoms of schizophrenia on October 17, 2018?
No, I don't believe Mr. Ray was exhibiting any signs or symptoms of schizophrenia. The only time Mr. Ray reports having hallucinations or delusions or paranoia was after he was arrested for his son's murder. And that leads me to my second opinion, that Mr. Ray was malingering.
Let's talk about that second opinion. What is malingering?
So malingering, like schizophrenia, is defined by the DSM-5. In layman's terms, it's faking symptoms or making up physical or psychological symptoms or grossly exaggerating them. And it's usually motivated by external factors.
What would be an external factor in this case?
For Mr. Ray, an external factor would be evading criminal prosecution.
Now, how'd you come to your conclusion that the defendant was malingering?
Well, like I mentioned before, with schizophrenia, we use the DSM-5 to give us factors to diagnose malingering. It also gives us an idea to see whether the person's faking symptoms.
So which of those two factors apply to the defendant?
The two factors I focused on, the first one being Major Riley's assessment of Mr. Ray occurred after he was arrested in the context of a criminal evaluation. The second factor I focused on were the major discrepancies between symptoms described by Mr. Ray during the clinical interview with Major Riley, and the symptoms documented in written materials, including medical records, all prior to the arrest.
So why does it matter that the defendant's assessment was in the context of a criminal evaluation?
Malingering is more common to occur when facing a criminal context. Here, Mr. Ray just murdered his son, and he's finding the only way for him to avoid criminal prosecution is to say he's schizophrenic.
Let's talk about that second factor now that you mentioned, discrepancies. What discrepancies are we looking for?
Well, for Mr. Ray's statements, he was reporting certain symptoms, but the objective findings just don't show this. We look at his complete psychiatric evaluation in 2010 with Major Riley, the 3 doctor's visits with Dr. D Giuseppe from 2010 to 2017. None of them show any objective findings of hallucinations or delusions. But after he's arrested, Mr. Ray is reporting them all in the clinical interview.
Your Honor, at this point, we would like to sidebar and discuss the witness's third opinion.
Okay, so what I would like to do first is have an offer of proof from you, Ms. Naughton, about how exactly this evidence is going to come out.
Yes, Your Honor. If allowed to testify, Dr. Legrecker will go on and say that there are factors that experts in his field, including Major Riley, will look at to consider whether a person knows right from wrong. I just simply want this witness to discuss these factors and break them down for the jury. I will not ask the witness, and he will not go into what the defendant did.
Is there going to be any reference to the defendant, his diagnosis, or otherwise during this line of questioning?
No, Your Honor.
Okay. Now, Ms. McCormick, do you still object on the same ground?
Yes, we do, Your Honor.
Okay. Why is it still objectionable if there's no reference to the defendant?
Your Honor, if I may read and call the court and counsel's attention to page 14 of the case packet. The excerpt from Pasquarello v. West Carolina states, and I quote, Rule 704B of the Federal Rules of Evidence forbids experts in criminal cases from testifying with respect to ultimate issues of a defendant's mental state or condition. In a case where the defendant makes insanity his or her defense, those ultimate issues at whether the time of the crime the defendant appreciated the nature and quality of the wrongfulness of his acts, or in other words, whether the defendant knew what he or she was doing was wrong, is not admissible. And if the state is going to talk about is not going to talk about the defendant's actions, then it's not relevant. So regardless if they could lay a foundation to get this information, it's still not allowed under Pasquarello v. West Carolina.
Okay, briefly to Ms. Naughton so if we're getting around Pasquarelli, whatever, by way of not making any reference to the defendant, assuming that's true, is it still relevant? And if so, why?
Your Honor, Pasquarello says that no expert may testify to the defendant's mindset. And that's exactly what we're doing here. The defense has willingly taken up an insanity defense in the jurisdiction's laws, which, if I can direct your attention to page 11, dictates that in order to have insanity, the defense must prove that the defendant was unstable to appreciate his actions. The defense is going to attempt to do this by calling Major Riley. While we cannot call a rebuttal witness, we must present this evidence in our case in chief.
See, my concern is that the response to why it's relevant goes right back to the defendant, which is why reference of the defendant is violative of the Pasquarello rule. But all that being said, what I'm going to do is I'm going to overrule it despite defense's very sound objection. And what I'm going to do, I'm going to issue a very specific jury instruction that both of you can draft and have on the bench before 9 a.m. tomorrow morning, so I can know what exactly to tell the jury, so they understand that the doctor did not apply this opinion to the defendant, and no finding has been made as to whether this defendant appreciated the wrongfulness or consequences of his actions. So,
Your Honor, if I may,
yes.
we would ask that we would be able to re-raise this objection if we believe that the state goes into too far into this questioning.
Sure. Yep. You retain that right. But based on all of that and with the jury instruction, I'm going to overrule.
Dr. Legrecker, in regards now to your third opinion that schizophrenic people in general don't know right from wrong, how can we know this?
Several factors are considered, including whether someone hid evidence or whether someone feels justified in their actions.
Let's start by talking about that first one, hiding evidence. What's the significance of that?
Hiding evidence is a hallmark indicator that a person knows his actions are wrong.
Okay, and can you tell us about the second thing that we should look at, whether someone feels justified in their actions?
When someone understands their
Objection,
actions.
Your Honor.
Yeah. On what grounds?
This is all information not included in the case packet. If state could point to where they received this information, we would be glad to look into it.
Well, I mean, if there's a okay, so let's talk about Federal Rule of Civil Procedure 26 real quick. Any expert opinions are all disclosed in reports to either side prior to trial. If it's the case that we're going into territory of the opinion that wasn't disclosed, and that's one reason for exclusion. But if the state can point to anywhere in his expert report or anything else that he has that has his name on it essentially and is provided in the case packet, then we should be okay. But so Ms. Naughton, is there anything, can you point us to where there's a basis for this?
Yes, Your Honor. I would like to direct your attention to the witnesses report. It's page 76, line 1.
Hiding evidence is a hallmark indicator, that line?
Yes.
Yeah, I think that's sufficient overall.
Now, Dr. Legrecker, can you tell us about the second thing to look at, whether someone feels justified in their actions?
Someone understands their action is wrong, or they punish someone, they look to justify its cause.
No further questions, Your Honor.
Okay. Cross-examination.
Yes, Your Honor.
Sorry.
Dr. Legrecker, the state's paying you to be here, correct?
Correct.
They pay you $500 an hour just to review materials?
Correct.
They're paying you $1,750 just to testify about those materials today?
Correct. It also accounts for room and board and different resources I used for this case.
You mentioned earlier that you were working on a study to be published about malingering.
Yes.
You used this study to aid in your evaluation of Mr. Ray.
Yes.
This study is not on schizophrenia?
It's on malingering.
And the study is not complete, is it?
It's a work in progress. Yes.
Now, on direct examination, you also spoke about your opinion that Mr. Ray is malingering. You
Yes.
relied on Major Riley's report to form this opinion?
Yes.
And it included that the United States Army reported Mr. Ray was seeing things in 2010.
Yes, but as noted by Major Riley himself, Officer Cruz is known to bend the truth.
Objection, Your Honor.
Okay. On what grounds?
The witness is testifying about reputation evidence. One person cannot create a reputation. This would be improper character evidence.
Overruled.
And it's true that he did deny the symptoms ultimately.
Absolutely, yes.
But you would agree that lack of insight into one own, that would be into lack of insight into one own's disorder.
Yes, but lack of insight by trained physicians as well.
And lack of insight into one own's disorder is actually an associated factor of schizophrenia, isn't it?
Yes.
Dr. Legrecker, let's talk about what else you read in that report. You learned that Mr. Ray would lock himself in the bathroom for hours, didn't you?
Correct.
That his own mother suffered from severe mood swings.
Mood swings, yes.
He attacked a coworker for not following directions.
Yes.
That on the night he was arrested, he seemed disheveled.
Yes.
That he exuded body odor.
Yes.
And all of this occurred before he was ever arrested.
Yes.
You also relied on the transcripts of the law enforcement interviews.
Yes.
That included the transcript between Officer Wentz and Detective Booth.
Yes.
And that's where you learned Mr. Ray asked if Officer Wentz was with the CIA
Yes.
more than once.
Yes.
And that Officer Wentz had observed strange behavior.
Yes.
That he even expected an EMT to arrive on scene that night.
Yes.
You relied on the transcript of Detective Booth's interview with Mr. Ray.
Yes.
He asked Detective Booth if he was working with the CIA.
Yes.
And yet your opinion still is that Mr. Ray is malingering,
Yes.
given all of that evidence of delusion
Yes.
and hallucinations.
Questionable, but yes.
And you base this opinion off of the DSM-5.
Yes. As would every other psychiatrist.
You would agree symptoms can emerge between mid-teens to mid-30s?
They can, not always though.
And the DSM-5 definition of malingering also says 19% of people are found to be malingering.
The DSM-5 does not say that.
The DSM-5 definition of malingering does not say that?
Not that statistic.
Calling court, counsel, and witness attention to page 94 of the case packet. Is it your testimony today that the DSM-5 does not include 19% of people are found to be malingering?
Yes.
Objection, Your Honor. Asked and answered.
I mean, I think she was re-asking the question for the sake of the impeachment to overrule.
Your Honor, I would apologize. I would like to bring your attention to Dr. Legrecker's report. Dr. Legrecker, in your report, did you state that 19% of people are found to be malingering?
I'd have to check, but I believe this was in Major Riley's report.
A moment to confer, Your Honor.
Yes.
Or,
No further questions.
Okay. Any redirect?
Yes, Your Honor.
Whenever you're ready, counselor.
Dr. Legrecker, you use the DSM-5, is that correct?
correct.
And when did the defendant report the instances of hallucinations?
He reported them only after he was arrested.
And when did the defendant report the incidence of delusions or paranoia?
He reported them only after he was arrested.
No further questions, Your Honor.
Thank you, Dr. Legrecker. You can turn off your camera. Does the state have any further witnesses today?
No, Your Honor.
Okay. Do you have anything other than witnesses to present?
No, Your Honor. The state rests its case in chief.
Okay. In that case, defense, do we have any applications to make at this time?
Yes, Your Honor. May we make a motion, Your Honor?
Absolutely.
Pursuant to Federal Rules of Criminal Procedure 29A, defense moved for a judgment of acquittal, even when viewing the evidence in a light most favorable to the non-moving party. In this case, the prosecution has failed to prove a prima facie case specifically as to the first-degree murder so that a reasonable jury could find for them. The defendant in this case is charged with first-degree murder and has to be shown that they had caused the death with malice of forethought. In this case, can be considered used with premeditation. Now, in order to prove premeditation, they have to show the consideration to kill, the decision to kill, and the killing arising from that decision. The state did not establish the sequence of events, and they cannot establish whether the alleged person killed with malice of forethought.
Okay, thank you, Mr. Marcus. People, let's just limit your response to the specific issue of malice of forethought, okay?
Yes, Your Honor. This jurisdiction actually dictates that malice of forethought can be met if the jury finds that the defendant intentionally murdered his son. We have proven that, Your Honor, through the testimony of Detective Booth, that everything the defendant did that day was intentional.
How?
Your Honor, the defendant intentionally went and grabbed the belt. He intentionally put that belt around Nathan's neck, and then he intentionally pulled that belt. That's what the defendant told Detective Booth.
Understood. Thank you. Motion denied. Anything else?
No, Your Honor, not right now.
Okay.
Are we moving on, or are we taking a break, Your Honor?
No. I think we should take a break before we move on to the defense's case in chief. But before that, I would like to hear from the timekeepers. First, if you could take 30 seconds to kind of compare your notes and to see if you were in substantial agreement. If so, then let's hear where we are on time. If you're not, then you guys should try to discuss it and work it out over like a 5-minute break, and then we can figure it out from there.
Thank you, Your Honor.
I'm the timekeeper for the defense. I just sent the times that I have to prosecution counsel. We're in agreement on the prosecution's time. They have 25 minutes remaining. My time for defense is 38 minutes and 9 seconds remaining. I apologize.
Okay. And so how far off are we on the defense's remaining time?
I'm still waiting to hear from prosecution's timekeeper.
Gotcha.
Your Honor, we are off by a mere 3 seconds, so we will stipulate the time concerning the defense's remainder of time.
That is beautiful news. Okay, so we've got our time check done. We've got our motions done. Let's reconvene at 50 or 10 minutes to the hour. That'll be 5:55 or 5:50 for us East Coasters. I don't know what it is for the rest of you. But so yeah, see you in 5 minutes. Yeah, so let's have everybody turn their camera on just so I know when we're all back before we get started. All right. Okay, great. That's everybody. Okay, then. State has rested. Defense, would you like to put on a case at this time?
Yes, Your Honor. At this time, we would like to call Officer Peyton Wentz to the stand.
All right, Officer Wentz. Let's see him.
May I inquire?
Yes, you may.
Good afternoon. Could you please state your name for the record?
Hello, my name is Peyton Wentz.
What do you do for a living?
I am a police officer with the Skeleton Police Department.
How long have you been an officer for?
It's been about 4 years now. I can't believe it.
Before becoming an officer, did you go to school?
I did. I got my bachelor's degree in criminal justice before I joined the force. And then after I joined the academy, we had to go through additional training.
Did you have any specialized training at the academy?
Yes, I did. I participated in a special training program called the Crisis Intervention Training Program. It's basically a program designed to educate us on mental health issues and train us on how to interact with individuals with mental health issues as well.
How long did it take to complete that training?
That was a 40-hour training program. It covered things like how to recognize the signs of mental illness, as well as training us on de-escalation and, when interacting with individuals with mental health issues.
Officer Wentz, I want to talk a little bit about why we're here today. How did you become involved in this case?
I was assigned to the DUI checkpoint where the defendant was later apprehended by us, and I was the one who initially made contact with him that evening.
I'd like you to walk me through that evening. So let's start with what you noticed once you made that contact. Could you describe what Mr. Ray looked like?
Yes. So when his car pulled up to the DUI checkpoint, I signaled to him to roll his window down, and I saw that he, appeared to be disheveled. His hair was a mess. His eyes were glassy. There were stains all over his shirt, and the car appeared to be a mess as well.
After making those observations, what did you do?
I had Mr. Ray pull over to the side of the DUI checkpoint so, I could do a little more investigation.
What happened next?
I asked for his license and registration like I do with every car that pulls up to the checkpoint.
Officer Wentz, what did you do once you had that information?
I took that information back to my partner at our patrol car and had him run the information.
And at that point, did you go back to Mr. Ray's car, or did you also stay with the other officer?
Once I had the information, I had my partner run the information, and then I headed back to the defendant's car.
Once you got back to his car, what happened?
Well, I approached the driver's side window, and as I did, Mr. Ray started to yell and ask me if I was with the CIA.
Officer Wentz.
Objection, Your Honor. Hearsay.
Okay, response.
Your Honor, this has been previously discussed. It's also a question that Mr. Ray, the defendant, asked. It's not a statement, so it wouldn't qualify as hearsay.
The statement is asking whether or not they're with the CIA?
Yes, it is, Your Honor.
Overruled.
I'm going to ask my question again. Once you got back to his car, what happened?
Oh, sorry, I was muted. As I was approaching his car, he saw me coming and asked if I was with the CIA.
Officer Wentz, are you with the CIA?
No, I'm just a skeleton police officer.
Is that all Mr. Ray said at the time?
No, he also said that he could hear the sirens of the CIA coming to get him.
Officer Wentz, were there any sirens that night?
No, we had the lights on our patrol car, but there were no sirens at the DUI checkpoint that evening.
How did you respond to that?
Well, I showed him my badge. I, assured him that I was not with the CIA and that I was just a police officer. I had my uniform on, but he kept asking me if I was with the CIA. So I finally asked him to step out of the vehicle.
Let's talk about what happened once he got out of the car. Could you describe your observation that you made of Mr. Ray?
Yes. So when he was stepping out of the vehicle, his demeanor changed almost immediately from what I had just seen before.
Could you describe that change to the members of the jury?
Sure. So he sort of started to act like a zombie, just moving very slowly. His face went blank, started to talk in a monotone voice, just very strange behavior.
Did this continue for long?
No. But shortly after he stepped out of the vehicle, he started to do jumping jacks.
What did you do at that point?
I tried to get him to stop moving. He wouldn't, at least not right away, until I was forced to pull my gun on him.
What happened then?
Once I was finally able to get him to stop moving, he's doing the jumping jacks. He put his hands over his ears as if he was a little kid trying to stop from hearing something, and he was moving his head around uncontrollably.
Officer Wentz, would you mind demonstrating to the jury exactly what he was doing?
Sure. So he had his hands over his ears like this, and he was shaking his head very violently, I would say, actually.
Did he ever stop doing that?
Yes, he did. I was able to get his hands behind his back and handcuff him.
And at that point, was Mr. Ray under arrest?
No, we were just detaining him at that point.
So what happened after you handcuffed him?
Then I went to check back in with my partner. I sat Mr. Ray down on the curb, and I went to call what I had just observed into the station.
And what did you learn when you talked to your partner?
I learned that the information we provided, his license and registration, had come back flagged on a missing persons report. So that's when I made sure I went to call it into the station to get someone to respond to the call.
You've called what you found into the station. What happened next?
Shortly after I made that call, Detective Booth from the Homicide Division responded to the scene.
Were you expecting anyone different?
I was expecting an EMT along with Detective Booth, but an EMT didn't come.
Did that surprise you?
Yes. Well, based on what I had reported just minutes before when I called about, describing Mr. Ray's observations and what his behaviors were, I suspected that they would send an EMT.
And once Detective Booth arrived, did you leave the checkpoint?
Yes, I did.
So let's focus on your drive now to the station. What did you notice during that time?
He was a lot calmer at that point. He was just sitting in the back seat of my patrol car, kind of just talking to himself in the back seat.
You've arrived at the station. How did Mr. Ray act once you were there?
We put him into an interview room. He started to cry a little bit and just seemed very upset. He put his head down on the table and was just, silent until Detective Booth got there.
Officer Wentz, did you sit in for the interview?
No, I did not.
Did you have any further involvement in the case?
No, once I put the defendant in the interview room, I left.
A moment to confer, Your Honor. No further questions at this time.
Okay. Cross.
Officer Wentz, I want to talk to you first about when you first pulled over the defendant. He was coherent?
I would say so, yes.
He was answering all of your questions?
I wasn't asking him many questions at that time, but so I guess you could say that.
He wasn't slurring his words?
No.
He also was antsy?
Yes.
Squirrely?
Yes, I'm not sure what that word really means, but I guess you could say that.
Even defiant?
I wouldn't really say defiant, no.
You'd agree with me that the defendant tried to avoid being identified by you.
Well, he handed me his identification.
But first, when you asked for his license registration, he actually lied to you and said he didn't have it.
He did, yes.
So he didn't give you his license or registration right away.
No, once I asked for it, he, tried to kind of get around it, but then he ultimately did give it to me.
And then after he gave it to you, you walked back to your car to give your the license registration to your partner.
Yes.
And at that time, the defendant was in his car alone.
Yes.
Now let's talk about when you got back to the defendant's car.
Okay.
Officer Wentz, we can agree that the defendant's behavior noticeably changed after you went to run his license and registration.
I would say so, yes.
He asked you if you were in the CIA?
Multiple times.
He asked you that after you had his identification?
Well, that's the way it went, yes.
He told you that he could hear sirens from the CIA coming to get him?
Yes.
He only asked you that after you returned to his car.
Yes, he couldn't ask me if I wasn't at his car, so yeah.
You said he was acting like a zombie?
Yes, that's what I said.
He only acted like that, though, after you returned to his car.
Yes.
Let's discuss now how his behavior changed again after you had arrested him. So after you had handcuffed the defendant, he didn't ask you about the CIA, did he?
I'm not too sure how many more times after that did he, but I don't think so, no.
And he wasn't hearing sirens?
I don't know whether he was or not, that's just what he said.
He wasn't acting like a zombie.
At what point?
After you had handcuffed him and sat him on the curb.
No.
So once you had arrested him, all of these strange behaviors and actions stopped?
Well, I would say he was acting strange throughout my whole interaction with him. Just different versions of it, I would say.
No further questions, Your Honor.
Okay. Any redirect?
Yes, Your Honor. Officer Wentz, did Mr. Ray ultimately comply with all of your orders that evening?
Yes, he did.
And after he was handcuffed, did he continue to comply with your orders?
Yes, he did.
And how would you describe his demeanor after he was handcuffed?
I would just say he was calmer, but, just monotone and still acting very strange throughout my whole interaction with him.
A moment to confer, Your Honor.
Sure.
No further questions.
Okay, thank you very much, Officer Wentz. Any further witnesses at this time?
Yes, Your Honor. We would like to call Major Riley.
Okay, Major Riley.
Hello.
May I inquire, Your Honor?
Yes.
Good evening, Major Riley. Would you please introduce yourself to the jury?
Hello, my name is Major Shane Riley.
And what do you do for a living, Major Riley?
I'm a military veteran, and I'm also a military forensic psychiatrist.
What does one do as a military forensic psychiatrist?
This particular field of medicine I practice is a mix of psychiatry, the law, and the military.
And is any schooling or training required to become this type of psychiatrist?
Yes, I had to complete several years of school and clinical experiences.
Can you tell us specifically what schooling you completed?
I received my BA in biology from Notre Dame in 1993. I then attended the Uniformed Service University School of Medicine, where I received my MD degree in 1997. I decided to enter my class as a commissioned officer in the U.S. Army, and I graduated fourth in my class.
When did you complete your psychiatric residency?
So after my graduation, I completed a 4-year psychiatric residency at Walter Reed National Military Medical Center, where I was able to teach and work with medical students in the field.
And after this, did you complete any additional training?
Yes, I completed 1-year fellowship in forensic psychiatry at the same medical center in 2003.
Major Riley, what was your next step after completing this training?
After finishing my fellowship, I continued to work as a forensic psychiatrist. I held 3 different positions in the field before starting my own private military forensic practice.
And what was his first position?
Right after my fellowship, I began my 7-year service requirement as a captain in the U.S. Army. I served in Iraq as a psychiatrist for 2 years, and I was the primary psychiatric consultant for the division commander who oversaw 20,000 soldiers.
And what was his second position?
My second position in 2006, I accepted a clinical assignment managing the hospital psychiatric inpatient unit at the Walter Reed National Military Medical Center.
Could you just briefly explain your duty there?
Sure. I treated hundreds of military personnel suffering from a wide variety of mental health disorders, such as schizophrenia, but I also work with residents and I taught courses related to forensic psychiatry.
And what was your third position?
In 2011, I was the Deputy Director of the Department of Behavioral Health. So I continued working in the psychiatric inpatient unit, and I provided evaluations, crisis management, substance abuse intervention, and discharge planning services to patients.
At what point were you promoted to major?
2014.
And is this when you decided to open up your own private practice?
I decided to open my own private practice shortly afterward in 2015.
Can you explain more to the jury about this private practice?
Yep. So I opened my own private practice in military forensic psychiatry because of my experience in both the military as well as in medicine. I wanted to offer my services to former veterans who are parties in legal matters, but I also offer services to the civilians.
And I understand you touched generally on it, but could you please explain the specifics of what you do as a military forensic psychiatrist?
Sure. The main focus includes the command-directed mental health evaluation, but I also train in the course of civilian forensic psychiatry, which includes the treatment and consultation with persons involved in the justice system and courtroom testimony.
You mentioned that you have over 17 years of experience as a forensic psychiatrist. Have you contributed any work to the field of forensic psychiatry?
I published my first study in 2007 on military psychiatry regarding diagnosis of military personnel while deployed in Iraq.
And was this your only published study?
No, I've also written 15 peer-reviewed articles with the majority relating to forensic psychiatry and 2 relating to schizophrenia.
Major Riley, you told us earlier that you offer services to parties in legal matters. What experience do you have in legal matters yourself?
I have served as an expert witness 25 times, 7 of those times in court-martial proceedings and 18 times in civilian criminal proceedings.
And do you normally testify for one side or the other?
I offer my services to military veterans, not the government. So the one times I have testified, I was retained by the defense.
And what are you hired to do when you are retained?
To give an opinion. To do that, I review materials like
Your Honor, you may have frozen. Is it okay if we just take a moment, maybe redo the question?
Major Riley, are you back with us? You froze there on our feed for a moment.
Okay, I can see and hear you. Can you guys hear me?
We can hear you. Do you want to try to give that answer again?
Can I ask the
sure.
question again, Your Honor?
Sure. Yes. Re-ask the question. That's even better.
Thank you, Your Honor. What are you hired to do when you are retained?
To give an opinion. To do that, I review materials like medical records, conduct interviews, and provide evaluations.
Are you paid as an expert witness to testify?
Yes, but that just means I'm paid for the services I provide in my own private practice.
And what are the fees that you charge as an expert witness?
I charge $450 an hour to review materials, and I charge a flat fee of $1,500 a day for testimony.
Your Honor, at this time, we'd like to tender Major Riley as an expert in the field of forensic psychiatry.
Any objections from the state?
None, Your Honor.
Okay, he is tendered as an expert in forensic psychiatry.
Now, I want to talk about this case, Major Riley, and your role in this trial. How did you get involved in this case with Mr. Ray?
I was retained by your team in 2019, but I actually treated Mr. Ray in 2010 at the Walter Reed National Military Medical Center.
And as a forensic psychiatrist, how do you conduct your evaluation of Mr. Ray?
For a patient like Mr. Ray, I review materials of a case to form an opinion regarding whether and to what extent patient like Mr. Ray himself may suffer from, including any mental disorder that would affect his ability to discern right from wrong.
And can you tell us what specifically you relied on to form this opinion?
Sure. I relied on several things during my evaluation. This included his former 2010 treatment at the medical center where I first met him, other corresponding medical records, materials supplied to me by his counsel, and my own clinical interview with Mr. Ray, and additional interviews with his former employer, his father, and his wife.
Did you rely on any medical or psychiatric materials?
Yes. I considered the DSM-5 definition of schizophrenia, his family history, his childhood trauma, and related mental illnesses.
Were you able to form an opinion in Mr. K's case using those materials?
Yes, I was.
And did you form this opinion to a reasonable degree of medical certainty?
Yes, I did.
Now, I'd like to go back to your former treatment of Mr. Ray and your analysis. Could you please tell the court about the former treatment in 2010 of your evaluation of Mr. Ray?
Sure. Mr. Ray was discharged from the Army and evaluated by me for other designated physical and mental condition. It was reported at the time that he was seeing things. During my evaluation, I found...
Okay. The statement to it being reported that he was hearing things, is that
Your Honor.
Okay.
Your Honor, if I may.
Mr. Marcus, yes.
Yeah. An expert is allowed to bring in inadmissible evidence as long as they reasonably use it in forming their expert opinion under 704.
Your Honor, if I may respond to those grounds.
Yes.
I believe opposing counsel is mentioning 703, and he is right. Expert witnesses are allowed to rely on otherwise inadmissible evidence, but only if the probative value helps the jury and is if the probative value is outweighed by the prejudicial value. Your Honor, the prejudicial value in this case is a statement of a non-expert 10 years ago saying that the defendant was seeing things, a person who actually has a reputation of bending the truth. It doesn't meet this threshold and should be inadmissible pursuant to Rule 703.
Well, I mean, I think at least that if he has a reputation for bending the truth, it goes to weight, not admissibility. And I think otherwise 703 pretty much covers us here. So overruled.
I'm going to ask that question again, Major Riley.
Sure.
Now, I'd like to go back to your evaluation. And could you please tell the court about your former treatment of Mr. Ray in 2010?
Yep. So Mr. Ray was discharged from the Army at the time, and he was evaluated by me for other designated physical and mental condition. It was reported that he was seeing things. During my evaluation with Mr. Ray, I found him to be cooperative and with no past psychiatric history. I found that he was of no harm to himself or others, so he was released 3 days later from the medical center.
And at the time of this initial evaluation that you conducted, did you diagnose Mr. Ray with any medical illness?
Yes, I had diagnosed him with generalized anxiety disorder, and I prescribed him Paxil, as well as recommended follow-up treatment from a therapist for his diagnosis.
You also mentioned that you were able to meet with Mr. Ray 9 years later for evaluation. Was this evaluation any different from the last?
Yes, it was very different. I met with Mr. Ray on September 8 of 2019. He was still cooperated as he was in 2010. But this time we spoke at length about the symptoms that he's been experiencing, and I was able to evaluate a much more detailed psychiatric history than my previous interview.
And during this interview, what did Mr. Ray report to you in regards to his mental health history?
I learned that Mr. Ray had been experiencing many symptoms of schizophrenia throughout his life. He never told anyone because he feared that he would be labeled as mentally ill and institutionalized.
Speculation, may I be heard?
Yes, please.
Speculation as to why the defendant never told anyone of these alleged symptoms.
Okay, Mr. Marcus.
Your Honor, again, he's just using inadmissible facts from his own report, and he told Dr. Riley that he would never experience these symptoms because he feared he'd be labeled mentally ill.
Well, I mean, we haven't had the foundation yet for the fact that information came from him, so sustained pending that foundation being laid.
Your Honor, if I may, the foundation was that during the interview, he reported to Dr. Riley that he feared he would be labeled as mentally ill. That would be the foundation, Your Honor.
Yeah, but was that actually contained within the answer?
Yes, Your Honor, it was.
Is that your understanding?
I could proffer it to you if you would like, Your Honor.
No, Your Honor, I don't believe the foundation was laid that this opinion is coming from what the defendant told this witness.
I didn't hear it either, and it's possible that I missed it. But just to make sure that the record is clear, why don't you just ask that quick foundational question, and then we'll be okay.
Yeah, of course. Did Mr. Ray ever ask you anything about why he didn't say anything about these mental symptoms?
Yes, he said that he never told anyone because he feared that he would be labeled as mentally ill and institutionalized like his mother.
And can you just, for the help of us, can you tell us about the symptoms? What are schizophrenia?
Sure. According to DSM-5, symptoms of schizophrenia include delusions, hallucination, such as hallucination could be auditory, visual, smell, touch. Other symptoms of schizophrenia include disorganized speech, disorganized behavior, catatonic behavior, and negative symptoms like diminished emotional expression. A patient would have to experience at least 2 of these symptoms for at least a month.
And are there any other symptoms of schizophrenia, Major Riley?
Yes. Other symptoms would be such as impairment in one of the major areas of functioning since the onset of disturbance, such as impairment to work, interpersonal relations, or self-care, so long as the disturbance was not caused by any other medical condition or substance use disorder.
What symptoms did Mr. Ray present?
Hallucinations, delusions, and negative symptoms. Certainly for over a month, but he also shows signs of impairment at work with his wife and also with caring for his own hygiene, personal hygiene.
And to be diagnosed with schizophrenia, do you have to show all 5 of these symptoms?
No.
Now, I'd like to walk through the symptoms as seen in his history. In your medical opinion, what was the first signs that Mr. Ray was experiencing symptoms of schizophrenia?
Mr. Ray had been hearing voices which would come and go for years at the time since he was 10.
And did he tell you anything about the voices that he heard?
Yes, he told me that in 2015, he heard voices about his family. The voices insisted that his wife was cheating on him and that his wife and son would cut him up with a knife and leave him.
Was he able to describe these voices?
Yes.
And how did he describe them?
He said they were male voices that would randomly pop up.
Did he express any other symptoms of schizophrenia during his interview?
Yes. In 2016, Mr. Ray began having recurrent and raising negative thoughts. By 2017, he started having visual hallucinations, which he described as triangles on the wall, which changes shapes and color.
Did these symptoms continue?
Yes. In 2018, leading up to the incident, Mr. Ray reported that the voices and hallucination had returned.
And during your assessment, was Mr. Ray able to recall the day of the incident?
Yes. He described that on the morning of Nathan's Ray's death, he was feeling stressed and anxious about work. After Nathan had spilled his juice onto Mr. Ray's laptop, he began to hear voices.
And can you explain what those voices tell him to do?
He heard a voice telling him that Nathan had spilled the juice on purpose and was trying to sabotage him.
And what did he report happened next?
He had punished him with physical training, quote unquote, to remove the evil. And when Nathan stopped complying, Mr. Ray became very upset and he heard a voice telling him to strangle Nathan.
Was he able to describe what happened after the voices told him to do that?
Yes. He said he went to his bathroom down the hall. He tried to calm down, but eventually he took a belt from his dresser and strangled Nathan with a belt.
Did he ever tell you why he did that?
He just heard the voice telling him to do so, and he felt like he had to.
Did Mr. Ray express at any time how the incident made him feel?
I asked if he thought what he did was wrong. He said he had to punish him.
Major Riley, what other questions you asked during your interview with Mr. Ray about his actions?
I asked Mr. Ray whether he would have done it same thing if a police officer had been watching. He responded yes.
Just to clarify, Mr. Ray did admit that he would strangle his son in front of a police officer because he felt like he had to?
That's correct.
Now, do you consider your patients' behaviors during your interviews and their evaluation?
Yes.
What behaviors did you observe of Mr. Ray during his evaluation?
During the interview, Mr. Ray was well-groomed, well-dressed, and he was cooperative. He spoke coherently and eloquently for nearly all of the interviews. However, towards the middle to the end of the interview, there was a change in his behavior.
Could you describe that change?
At first, he began to sweat a lot, but then he had a burst of anger where he became combative and he was accusing me of being a government agent. He believed I was out to get him.
Can you give us another example?
For example, he thought that there was a camera in my office microwave.
Major Riley, do you have a camera in your office microwave?
No, I do not.
Now, what happened after that?
He was able to calm down after the few minutes, and I was able to finish my interview.
Was there any additional issues during your interview that you believed that he believed you were a government agent?
Well, yeah, we stopped the interview another 2 times because he was crying uncontrollably.
Your Honor, the question calls for speculation.
I mean, we got the answer, and it wasn't a particularly speculative answer. Unless you have an issue with an answer, I'm gonna.
No, Your Honor.
All right.
Now, earlier today, the court was informed of your medical term malingering. Do you take malingering into account during your interviews and evaluations with clients?
Always. There's always a possibility, especially when the punishment is severe.
And what are some of the signs that you can rely on to determine whether an individual is malingering or not?
There are 4 different signs. 4 signs. The first one is that the medical legal context of the evaluation. The second sign is any marked discrepancy between the patient claim, stress or disability versus the objective findings. Number 3 would be the lack of cooperation between the diagnosis, evaluation, or in complying with the prescribed treatment regimen. And lastly, presence of antisocial personality disorder.
And with any of these factors, did you consider that Mr. Ray was malingering?
I did. However, I came to a reasonable degree of medical certainty that he was not.
And why is that?
So Mr. Ray had a detailed history of mental illnesses that is corroborated by previous medical records and my other interviews, detailing symptoms that began prior to him needing to establish a legal defense.
Now, you previously interviewed him in 2010. Why didn't you report any symptoms then?
Right. So he did not want to report them at the time because he didn't want to sound crazy.
Your Honor, asked and answered this line of testimony, if I may, Your Honor.
Sure.
I believe opposing counsel started this line of testimony with Major Riley in the beginning of his direct when they discussed the 2010 meeting with the defendant.
Your Honor, if I may.
Sure.
I asked a question with regard to why he didn't mention it in the evaluation, but this is with regard to why he didn't mention it in light of his enlisting in the military, Your Honor. And I proffer that if you let him, the defendant, testify, he's going to end the sentence with he had just joined the Army.
Overruled.
Thank you. I'm going to ask that question again, Major Riley. You previously interviewed him in 2010. Why did he report any symptoms then?
He didn't want to report at the time because he didn't want to sound crazy. He had just joined the Army at the time.
Now, I want to talk about your additional interviews and your evaluations you learned with Mr. Ray. Now, during your interview with Mr. Ray's father, what did you learn?
I learned that Mr. Ray suffered from child abuse by the mother who showed symptoms of severe mood swings.
And during your interview with Mr. Ray's previous employer, were you able to gather any information about Mr. Ray's mental health?
Yes.
What were you able to gather, Major Riley?
His employer had told me a story where Mr. Ray had a prior incidents of violence and previous episodes of uncontrollable crying after physically threatening a coworker for not following directions.
And what did Mrs. Ray have to offer in her interview?
Mrs. Ray informed me of the long history in the marriage, having issues with mood swings, episodes of uncontrollable crying, and forced isolation.
And what evidence of this forced isolation do you have?
Locking himself in the bathroom for hours at a time.
Major Riley, are these all signs of schizophrenia?
Yes.
Now, based on your interview with Mr. Ray and the additional interviews you conducted, did you rely on any specific materials to help you form your opinion with regard to his mental health?
Yes, I rely on the DSM-5 and its definition of schizophrenia.
And during your interview with Mr. Ray, did you personally observe any of these symptoms of schizophrenia?
Yes, he shows signs of delusion. He thought I was a government agent with a camera in the microwave. There were episodes of angry outbursts. There were episodes of crying uncontrollably, as well as pressured and disjointed speech at times during my interview.
And during your additional interviews, did you learn of any further instances where Mr. Ray showed symptoms of schizophrenia?
Yes, the episodes of uncontrollable crying described by his employer, as well as the episodes of severe mood swings, uncontrollable crying, and forced isolation by his wife. These are all signs and symptoms of schizophrenia.
Could you explain what other materials were used to present signs of schizophrenia?
The testimony I read of both Officer Wentz and Detective Booth, as well as negative symptoms like changes in sleep patterns, angry outbursts, episodes of crying. These are the things that I consider to conduct my evaluation.
And according to these criteria, and you relied upon the DSM-5, what do these symptoms show evidence of?
Schizophrenia.
Do you believe Mr. Ray fits this criteria?
Based on my findings during the interview, medical records, witness testimony, and the definition of schizophrenia provided by the DSM-5, yes.
And what is your ultimate opinion in this case of Mr. Ray's mental health in the morning of Nathan's death?
I was able to form the opinion that Mr. Ray suffers from signs and symptoms consistent with schizophrenia on October 17, 2018.
Moment to confer, Your Honor.
Sure.
No further questions at this time, Your Honor.
Okay. Thank you, counsel. Cross.
Yes, Your Honor. May I proceed?
You may.
Major Riley, I want to get something perfectly clear. You think the defendant is schizophrenic, right?
Correct.
You think this because of his self-reports of hallucinations?
Well, that and also like from what his co-worker and his family described.
Right. So that's a yes to my question. Partly you think this because of his self-reports of hallucinations.
Partly yes.
And partly because of his self-reports of delusions.
Partly yes.
Now, on direct examination, you mentioned that the defendant's mother had symptoms of a mental illness, right?
Correct.
And this can be an indicator of schizophrenia.
That could be an indicator, yes.
You didn't speak to her.
I didn't speak to her.
You didn't get to diagnose her.
I didn't get to diagnose her.
But you got to speak with the defendant's father, isn't that right?
That's correct.
He didn't bring up hallucinations to you.
He didn't bring up hallucination to me.
He didn't bring up delusions to you.
No, he did not.
In fact, his father didn't appear to have any mental illness whatsoever.
That's correct.
I want to talk to you about your first examination of the defendant. That happened on April 26, 2010, right?
That's correct.
You conducted a full psychiatric evaluation.
Correct.
The defendant denied having hallucinations.
He did. He later reported that he did not want to mention it at the time because he just joined the Army at the time.
Major Riley, he later reported that after he was arrested, right?
That's correct.
But before he was arrested in 2010, when you asked him, are you having hallucinations? He said, I'm not. He denied it, right?
That's correct.
Same thing
Objection,
with
Your Honor, asked and answered.
Overruled.
Major Riley, same situation with delusions. In 2010, he denied having them, right?
That's correct.
Now you're aware that the defendant saw another doctor called Dr. D Giuseppe, right?
I'm familiar with that.
Let's talk about the defendant's meetings with Dr. D Giuseppe. The defendant first saw Dr. D Giuseppe between 2010 and 2011.
Sure.
The defendant once again denied having hallucinations.
Mm-hmm.
The defendant once again denied having delusions.
That's correct.
A couple years later, in 2014, the defendant saw Dr. D Giuseppe again.
Mm-hmm.
2014, the defendant denied having hallucinations.
Mm-hmm.
Defendant denied having delusions.
That's correct.
And then the third time, that was right before the defendant murdered his son, that he saw Dr. D Giuseppe, right?
Correct.
The defendant didn't claim to have hallucinations.
That's correct. But I want to point out the fact that Dr. D Giuseppe actually referred Mr. Ray to a psychiatrist at the time, but there must have been something going on. But then there was no evidence that he did not actually follow up with a psychiatrist.
Thank you, Major Riley, but that wasn't my question. My question was that even on the third time, just like the first one and the second one, the defendant denied hallucinations, right?
Correct.
Just like the first and second time, the third time the defendant denied hallucinations.
Correct.
And you're aware that you and Dr. D Giuseppe aren't the only doctors that the defendant saw.
It appears so, yes.
Well, you are aware that the defendant saw Dr. Nershiam, right?
Yes, is that the prison doctor?
Yes, that's the prison doctor. The defendant saw him, right?
Yeah.
This doctor conducted a full mental health evaluation.
Yes.
The defendant didn't claim to have hallucinations now.
No, he did not.
And he didn't claim to have delusions then either.
No, he did not.
Now, you mentioned on direct that you thought it was important to speak to the defendant's family, right?
Correct.
And you thought it was important to speak to the three people closest to him.
Correct.
So you spoke to his father, his boss, and his wife.
Correct.
Now, all three told you that they never saw the defendant have a hallucination.
No hallucination.
All three told you they never saw the defendant have a delusion.
That's correct.
All three told you that the defendant never told them about any hallucinations.
That's correct.
And all three told you that the defendant never told them about any delusions.
That's correct.
So Major Riley, let's get this straight. Before his arrest, no one saw the defendant have a hallucination.
That's correct.
No one saw him have a delusion before his arrest.
Yeah, except the first officer he worked with in 2010.
Oh, you're talking about his commanding officer, aren't you?
Right.
You know his commanding officer personally, don't you, Major Riley?
I do.
You went to basic training with him.
I did.
He has a reputation for bending the truth.
Objection, Your Honor.
On what grounds?
On the grounds of improper opinion and lack of foundation. If I may, Your Honor.
I'll sustain as to lack of foundation.
Your Honor.
I mean, you're asking him if he has a reputation for insinuating that, some community somewhere thinks of him as having that. So sustain.
I'll rephrase, Your Honor. Now, Major Riley, you yourself, you know him as a man who has a reputation for bending the truth.
That's correct.
Objection, Your Honor. Is this not the same question?
I mean, it's a little different. You know him as someone who has a reputation for bending the truth. Essentially, it's just asking him what he. It's not like it comes in as evidence of that reputation actually being true. So for that reason, it's permissible and it's overruled.
So Major Riley, back to where I was going. So even the only time that anyone has ever seen the defendant have a hallucination or delusion, besides the doctor with the doctor that's known to bend the truth, the only time anyone has seen hallucination or delusion is while the defendant is being arrested, right?
It appears that the the officer, once the detective Booth also seems to observe him displaying those symptoms as well.
Right. That's while he's being arrested.
Oh, correct. That's correct. Yeah.
Doctor, you're certainly aware of the medical term called malingering.
Yes.
That's when someone lies or grossly exaggerates about their symptoms.
That's correct.
As a forensic psychiatrist, you're always concerned about malingering.
That's correct.
That's because people have an incentive to fake their symptoms to evade criminal prosecution.
Yes.
Now, the more serious the crime, the more likely it is someone's faking their symptoms.
Yes.
Doctor, a murder charge is the most serious crime one can commit.
Yes.
So in a case like murder, there's a much higher likelihood of malingering.
Yes.
Doctor, you're aware that the defendant in today's case, he's being charged with murder.
Yes.
Now, a strong indication of whether someone's malingering is if you find discrepancies in a person's story, right?
Yes.
If you find discrepancies, especially as it relates to the small details.
That's correct.
You yourself found some discrepancies in the defendant's story.
I did.
First, the defendant told you that Nathan destroyed his personal laptop.
Correct.
Then he changed the story.
He did.
He changed the story and said that Nathan destroyed his work laptop.
That's correct.
There was another discrepancy you found, right?
That's correct.
First, the defendant told you that Nathan smashed his laptop.
Mm-hmm. Yes.
But again, the defendant changed the story.
Yes, he did.
He changed his story and that said Nathan accidentally spilled juice on his laptop.
Could you repeat the question again?
Sure. The defendant changed his story and he said that Nathan accidentally spilled juice on his laptop.
Yes.
Major Riley, it's possible that the defendant is grossly exaggerating his symptoms.
It's possible.
It's possible that the defendant is simply lying about his symptoms.
It's possible. There's
And
always
you
a
can't-
possibility.
And you can't tell us with certainty that he's not.
Well, I said with medical, certain medical certainty because it's his symptoms are preceding leading the legal defense.
I don't want to worry about his legal defense. I want to talk to you about malingering and the fact that you cannot tell the members of the jury with certainty that the defendant is not malingering. Am I right?
Now, I can still say that there's a small possibility. Let's just put it that way.
Major Riley, I'm asking you a simple question here. You can't say with certainty that the defendant is not malingering, can you?
I cannot.
No further questions, Your Honor.
Thank you, Mr. Aurora. Any redirect?
Yes, Your Honor. May I inquire?
Yes.
Major Riley, did Dr. Giuseppe feel comfortable formulating an opinion in Mr. Ray's mental health?
Objection. Our question calls for speculation. May I explain? Or may I be heard?
No need. If you want to lay some more foundation, then that's okay, but sustained without it.
Now, Major Riley, you reviewed the material provided by Dr. Giuseppe in her testimony?
Yes, I did.
And did Dr. Giuseppe ever feel comfortable formulating an opinion on Mr. Ray's mental health?
Your Honor, this question calls for speculation about the comfort level of a separate doctor.
Yeah, I agree. I think you still need a little bit more foundation there, connecting what he reviewed to how he would know how she felt, essentially. So just connect one more dot there.
Yeah, Your Honor. I mean, if I call the court and counsel's attention to it's her actual testimony, and I mean, I could proffer the words of what she actually said.
If he read those words, that's a question that you could ask him.
Okay. Major Riley, did you read those words in Dr. Giuseppe's report that stated that she was not comfortable relaying a mental opinion on Mr. Ray?
Yes.
Now, based on your findings, and I know the opposing counsel brought it up that no one knew, neither did father, what Abe thought she was suffering from, the mother. Did you, based on your findings, believe that she suffered from a severe mental illness?
Correct.
Now, finally, why didn't you diagnose him in 2010?
Why did I diagnose him?
Why didn't you diagnose Mr. Ray in 2010?
Oh, at the time, he didn't report any symptoms at the time, so I did not know.
Thank you. No further questions, Your Honor.
Very good. Okay. Thank you, Major Riley.
Thank you.
Defense, any further witnesses? I think you're muted, Mr. Marcus.
No, Your Honor. No more witnesses.
Okay. Anything further, or do you rest?
We rest our, or no, well, no. We rest our case in chief, Your Honor.
Okay. Anything further at this time before moving into closing, before we take a break and then move into closing arguments?
At this time, Your Honor, I would just like to renew my motion for judgment of acquittal.
I appreciate that, and I bet that the state still opposes it, and I bet I'm still going to deny it. So thank you for those great arguments. So is that it before we're ready to take a break and then go into closings? All right.
Yes,
In that case, timekeepers, can you do the same thing you did last time? Take a second, see if you agree, and then let's get a time check before closing.
I've chatted with prosecution's timekeeper. I have 14 minutes, 20 seconds for prosecution, but he hasn't gotten back to me whether he's on the same page as that. And then my defense time's likely a little off. When I was on the stand getting crossed, I forgot to stop the time, but we have more time than we need. So I think we'll be okay, but just to want to confirm with them.
Yes, Your Honor, I'm still in the process of calculating the totals.
Okay, take your time.
Your Honor, I have stipulated with the other timekeeper that we have 14 minutes and 20 seconds left for prosecution's closing argument, and we have 21 minutes and 22 seconds for defense's closing arguments.
That makes it easy. Thank you very much. Okay, 14:20 for pros, 21 minutes for defense. Let's not use all that time now. Let's just take a couple minutes break. We'll come back at 6:40. Let's call it 6:42 Eastern time. 42 past whatever hour it is for you guys, and then we'll go to closings. Okay, then. Do we have all our competitors back?
Yes, Your Honor. I believe the prosecution is present and ready to proceed.
Okay. That looks like everybody there. Cool. Thank you. Jurors, do you see where there's a little reactions button in the bottom ribbon of your screens? Can you give me like one of these thumbs up or these claps so I can see? I'm not actually sure if that'll show up. Maybe just turn your camera on for a second or give me like I'm here.
It shows up, Your Honor. They're here.
What's that?
It showed up. All three gave you the thumbs up.
Oh, cool. I don't know why I couldn't see it. Excellent. Okay. In that case, we are ready to proceed with closing statements. I would like, I recommend to the jurors that they go to the top right corner of their screen and click speaker view. And I would recommend to myself that I close the door because there's sorry about that. I realized there's television on in the other room and that wouldn't have been great for you guys. But yeah, so everybody changed to speaker view so you can clearly see the speaker. It's better for closings and statements. And you can proceed whenever you're ready. And one last thing, just double check that everybody who isn't a closer is muted. Okay. Whenever you're ready, counselor.
Yes, Your Honor. The defendant killed his son. Let me repeat this. The defendant killed his own and his only son, and now he's trying to get away with it. We don't have to go over every single gruesome detail of what happened on October 17, 2018, because the defendant admits it. He beat his son with a belt. He strangled his son to death, and he stuffed his son's body in a trash bag, drove that body to the park, and he dumped it in a shallow grave. And let me repeat this, members of the jury. The defendant admits he did all of those things. And so we've charged him with first-degree murder. Members of the jury, today we have the burden of proof. That means we had to prove to you beyond a reasonable doubt that the defendant murdered his son. Now, in order to prove this charge, the law says that we have to show you first that the defendant caused the death of his son, and second, he did so with malice of forethought. Members of the jury, we have met our burden. We have proven to you that the defendant murdered his son. So how did we meet our burden? First, we have proven to you that the defendant caused his son's death. He caused Nathan's death. Now, earlier, the defense told you that this case isn't about evidence. It's about evidence, not emotion. But in reality, members of the jury, it's about both. Well, let's start by looking at the evidence, the physical evidence, the evidence that no one can deny. In the defendant's house, we have the spilled juice, the broken laptop, and the belt. From the defendant's phone search history, countries that don't extradite for murder, how to get rid of a body, will bleach destroy a body? From the defendant's car, bleach, garbage bags, a bloody shovel. And finally, from the park, Nathan's body, just where the defendant said it was. Members of the jury, if this hard physical evidence isn't enough for you, you have that autopsy report. The autopsy report shows that Nathan died of asphyxiation. It shows that Nathan died from the defendant strangling his son with the belt. And finally, members of the jury, we have the defendant's own words. And I'm only going to say this one more time. The defendant admits to killing his son. There is absolutely zero doubt that this first element is met. So now we must look to that second element that the law defines of a murder charge. The second element is malice of forethought. Now the law defines this as killing a person willfully, deliberately, or intentionally. And members of the jury, we have proven this as well. Now on October 17th, Nathan accidentally spilled his juice. But while Nathan spilled his juice on accident, everything that the defendant did was intentional. The defendant intentionally tied a belt around Nathan's neck. He intentionally tightened that belt. He intentionally tightened that belt as hard as he could. The defendant intentionally tightened that belt until Nathan stopped crying. The defendant intentionally tightened that belt until Nathan could not breathe. And members of the jury, the defendant intentionally tightened that belt until his son was dead. The defendant intended to murder his son, and that's exactly what he did. He got mad at his son's simple mistake. He became blinded by his rage, and he murdered his son. So you might be asking yourself, why are we here? Why is the defendant not in jail already? Well, we're here because when the defendant realized he was caught, he began to think, how do I get out of this? He realized that he was caught for murdering his 6-year-old son, and now he's trying to get away with it. You've heard all trial about the defendant's excuses, that there's voices in his head and he's just following orders. The problem with that, members of the jury, is that there were no voices, none other than his voice screaming at his son and the voice of his crying son that he silenced forever. Now, you heard from Dr. Legrecker today, a board-certified psychiatrist who has both diagnosed and treated hundreds of patients with mental illnesses from anxiety all the way to schizophrenia. Dr. Legrecker told us that the defendant simply doesn't have schizophrenia, because if he did, we'd expect to see these telltale signs. We'd expect to see hallucinations. We'd expect to see delusions. But members of the jury, those simply don't exist in today's case. As a matter of fact, before this murder happens, the defense's own expert asked the defendant, are you having hallucinations? Are you having paranoia? And you heard him say, the defendant said no. The defendant denied having hallucinations. The defendant denied having delusions. And over the next 7 years, several doctor visits, he never once brings up a delusion. He never once brings up a hallucination. He never once brings up any paranoia. But what about the people closest to him? What about his wife, his boss, his father? None of them saw the defendant have a hallucination. None of them saw the defendant have a delusion. And the defendant didn't tell them either. No family member, no friend, no coworker, no one saw any of these telltale signs until he was arrested. The defendant didn't tell anyone he was hearing things, anyone he was seeing things until he was arrested. Major Riley told us so today. Now, Major Riley also told us that a common excuse is faking your symptoms. It's malingering. And it's actually very common when you're trying to evade criminal prosecution. And in cases like murder, where the charges are similar to what the defendant faces today, there is a much higher likelihood of malingering. There's a much higher likelihood that someone's trying to lie to evade criminal prosecution. And members of the jury, that's exactly what's happening today. The defendant tried to evade criminal prosecution 3 ways. First, he tried to hide evidence. Now, just hours after he killed his son, the defendant looked up. How do I get rid of a body? He looked up, will bleach destroy a body? Members of the jury, the defendant was trying to destroy Nathan's body with bleach. He was trying to get rid of Nathan's body. He didn't just want to hide Nathan's body. He wanted to hide himself. He looked up, what countries don't extradite for murder? The defendant wanted to avoid going to prison for killing his own son, but that didn't work. So we get to the second way the defendant tried to evade criminal prosecution, by lying to Officer Wentz. Officer Wentz stopped him at the sobriety checkpoint. He asked for the defendant's license and registration. The defendant lied. He said, I don't have my ID. I forgot it at home. Same thing with his registration. I don't have it. I forgot it at home. Why did he lie? Well, he lied because the defendant knows those are identifying documents. He knows his son has been missing for the past 2 days, and the last time anyone has ever seen Nathan alive is when Nathan was with the defendant. The defendant hoped that the officer would just let him drive away. But members of the jury, this didn't work either. So finally, we get to the third and most elaborate way the defendant is trying to get away with murder. Let's picture the scene. The defendant lied to Officer Wentz about not having his wallet, not having his ID, but he had to hand it over anyway. Now picture what the defendant is doing. He's sitting in his car by himself. He knows right in the back seat, he has that bloody shovel, he has that bleach, he has those trash bags, everything he used to hide Nathan's body. So what's going through his mind? Well, he's thinking, before Officer Wentz comes back, I better think of an excuse. And what better excuse than insanity? Officer Wentz comes back, the defendant starts asking him, are you with the CIA? Do you hear these sirens? He never said that to anyone before. Officer Wentz told you today that when Officer Wentz first asked for his ID, defendant, perfectly normal. When Officer Wentz came back though, that's when these questions about the CIA, that's when all these alleged delusions, hallucinations started. Defendant's lying. But you don't only have to take my word for it. Think back to what Dr. Legrecker said. Dr. Legrecker compared the objective findings to what the defendant said. Objective findings show over the course of 8 years, countless doctor visits, 2 full mental health evaluations, no doctor, no family worker, no coworker, including the defendant himself, ever mentioned hallucinations, ever mentioned delusions until he's arrested. That is malingering. That is lying about your symptoms. Now, you also saw the defense today try to discredit Dr. Legrecker. They said he doesn't have any published reports, that he doesn't have any reports. He's not qualified. But members of the jury, Dr. Legrecker told us he didn't publish any reports. He didn't publish any articles because for the past 23 years, he was busy treating patients with schizophrenia. He was busy actually treating patients with schizophrenia, not the defendant. Next, the defense tried to say that, oh, he's being paid. He can't be trusted. He's not credible. But again, members of the jury, what doctor would spend countless of hours to be here and testify to not be paid? In fact, their own expert is being paid. Let's talk about their own expert, Major Riley. Major Riley told us that he did not diagnose the defendant with schizophrenia back in 2010. But now, after he's being paid, he changed his opinion. Now, Major Riley tried to wiggle. He tried to get out of my question when I asked him, you can't know for certain. You can't tell us for certain that he's not malingering. But eventually, he had to tell you that. He had to tell you that he cannot sit here in front of you today and tell you that the defendant isn't faking his symptoms. But what Major Riley did tell you is factors to look at, including finding discrepancies in a person's story. Because members of the jury, it's easy to keep track of the big details, the date, the belt, the location of the body. But if you're lying, it's hard to keep track of the small things. And Major Riley told us the defendant lied about those small things. The defendant lied and said that Nathan smashed his laptop. But he changed his story and said that Nathan spilled juice on it. Same thing with personal and work laptop. The defendant lied about these small details. He's lying. He's lying about his schizophrenia to avoid going to prison for murdering his 6-year-old son. When Jessica Ray last saw Nathan on October 16th, she never would have thought that's the last time she'll see 6-year-old Nathan alive. And the next time Miss Ray saw Nathan was when Nathan was in a casket. A parent, they're supposed to be supportive. They're supposed to be understanding. But when 6-year-old Nathan did something as simple as just spilling over his juice, the defendant wholeheartedly did the exact opposite. The defendant killed his son, and he's lying about his schizophrenia to get away with it. Don't let him. Find the defendant guilty of first-degree murder.
Thank you, counsel. All right, let's hear from the defense.
May it please the court, counsel, members of the jury, evidence, not emotion. We told you in the beginning that this is what the case was about, and nothing has changed. What happened on October 17th of 2018 was an absolute tragedy. We are not here to argue that. We are here to explain why the state did not meet their burden today. And they didn't meet that burden because just admitting to a murder doesn't satisfy what they had to prove to you today. So let's talk about their burden. There is no argument. Timothy Ray took the life of his son. But remember, the evidence, it has to prove beyond and to the exclusion of every single reasonable doubt that he premeditated Nathan's death, that before he killed Nathan, he planned to do so. And members of the jury, there is no evidence of this. The moment Mr. Ray took was a moment to decide how he was going to punish his child. The evidence that has been presented of Mr. Ray's act, what he did with that belt, was one of impulse, a snap decision once those voices finally took over that morning. And the state has presented a case based solely off of emotion to prove premeditation, something that they weren't able to prove at all. They told you throughout this trial that Mr. Ray killed his son. And again, we do not argue that. But how many times did the defense counsel repeat that line to you just a few moments ago? And why? Because they want you to remember that line in hopes of distracting you from the fact that they didn't prove their burden. The one thing that they were required to do today. because they never proved to you that he wanted to kill his son. And they never proved to you that he planned to kill his son. That was their only job, to prove beyond and to the exclusion of every single reasonable doubt that Mr. Ray planned the death of Nathan. Now, later today, you will receive a verdict form. And because the state did not prove the one thing that they had to, you must check not guilty. Now, members of the jury, as you can see, there is a third option on this form. And I'm going to talk to you about that in just a moment, because I want to make it absolutely clear. Because the state did not prove premeditation, you must find that Mr. Timothy Ray is not guilty. It is if and only if you disagree with me and you find that there has been sufficient evidence of premeditation, that's when we talk about this third option. So let's talk about not guilty by reason of insanity. Members of the jury, that was our burden to prove in this case. But remember, that burden is much lighter than the one that the state has to bear to you today. Our burden is just by clear and convincing evidence. And as your jury instructions will show, it's just that it's highly probable, but it is more than a 50-50 chance of being true. So what is it that we proved in this trial? Well, we proved that at the time of Nathan's death, Mr. Ray suffered from schizophrenia to the point that he could not understand the difference between right and wrong. The state wants you to remember the trash bags. They want you to remember the shovel and the bleach, all the things that were seized from the car, that it shows Mr. Ray knew right from wrong. But that is not true. You will see in your jury instructions, knowing the difference between right and wrong only matters in the exact moment of Nathan's death, not at any other time. They said that there was evidence of a bloody shovel. But remember, there is no evidence that blood was shed on that day. As they told you, the cause of death was asphyxiation. So there is no evidence of a bloody shovel. You didn't see any test results of that shovel, something that the state would have had to prove to you in order to meet that burden. They also said there's no evidence that Dr. Riley or anyone else could see Mr. Ray having hallucinations. That is true. But that is because no one other than Mr. Ray can see his hallucinations. You cannot see a delusion and you cannot see a hallucination unless you are the person experiencing those hallucinations. And Mr. Ray told Dr. Riley that he did. Now, you heard in today's trial that Mr. Ray said he would have done the exact same thing had an officer been watching. Is that the answer of someone who knows the difference between right and wrong? No, that is the answer of someone who is suffering from schizophrenia and who has been suffering for the past 20 years of his life. So let's talk about what schizophrenia looks like. Members of the jury, you heard from both expert witnesses in this trial. Mr. Ray only needs to show 2 of the following symptoms for at least a month during his entire lifetime. So what's the evidence in this case that Mr. Ray has schizophrenia? Well, the evidence actually shows that he had 4 out of the 5 symptoms and listed factors, and he has been suffering for years, for 20 years. So let's start off with the first one, delusions, a false belief. He believed his wife and son were going to cut him up with a knife. He thought Officer Wentz and Detective Booth were CIA agents. He believed Major Riley was also with the CIA, his own doctor. He even believes that there was a camera in the microwave watching him, recording him. Members of the jury, those are delusions. Check. Hallucinations. Mr. Ray has been hearing voices since he was 10 years old. The United States Army reported that he had been seeing things. He was discharged shortly after. Officer Wentz testified that he watched as Mr. Ray covered his ears, complaining of sirens that didn't exist. Check. Grossly disorganized or catatonic behavior, it's simply behavior that doesn't make any sense. The hysterical crying. Major Riley learned of this hysterical crying through his interviews. And not only did he testify that he learned this, but he also witnessed this, just as Officer Wentz did during the investigation. Officer Wentz also described that at the DUI checkpoint, Mr. Ray was doing jumping jacks until he pulled his gun. Detective Booth even told you that he noticed strange behavior. Check. Negative symptoms, impairments to emotions or behaviors. You heard about the mood swings and the lack of sleep. You heard that he would lock himself in bathrooms for several hours. Those random angry outbursts at his coworker, at his own doctor, the messy hair, stained clothes, body odor. You can consider all of these negative symptoms. Both experts agree these are symptoms that are negative. Check. Which brings me to number 2 on this list, impairment in one of the major areas of functioning. Members of the jury, the evidence shows Mr. Ray not only struggled in relationships with others, but with himself. Throughout this trial, you heard countless examples of this. He struggled in a failing marriage. He attacked a coworker. He was socially awkward, even according to Detective Booth. And we know what Mr. Ray looked like the night that he was arrested. Just how Detective Booth would describe him during those weekend soccer practices. A mess and socially awkward. Check. The third item, the disturbance cannot be caused by a substance or another medical condition. We know that Mr. Ray has been diagnosed with anxiety. And as the experts say, anxiety is very common. Symptoms of schizophrenia, like these, those are not very common. Anxiety does not cause someone like Mr. Ray to have all of the symptoms that you heard about today. Check. You're also able to consider all 10 associated factors shown. And members of the jury, the evidence shows the jumping jacks at the DUI checkpoint, inappropriate. The reported lack of sleep is a disturbed sleep pattern. And we know Mr. Ray has diagnosed anxiety. Now, Mr. Ray's lack of insight into his own disorder, denying his symptoms back in 2010, not telling anyone else about what he was seeing, what he was hearing, until they finally took over. The state has tried to convince you that Mr. Ray does not have schizophrenia because he didn't have treatment for it. Well, that is actually a symptom of schizophrenia. And that's shown in the DSM-5, that their own expert relied on. We also know he was socially awkward and he attacked a coworker. Members of the jury, the evidence shows Mr. Ray suffers from schizophrenia. The evidence shows 81% of people do not fake their symptoms. The evidence shows Mr. Ray, well, he's part of the 1% of the world who suffers from schizophrenia. And the state, they told you a story because they want you to use your emotions to ignore the evidence in this case. Now, when you deliberate, we ask that you remember if, and only if, you feel there is sufficient evidence of premeditation, then you choose not guilty by reason of insanity. But I want to make this very clear, members of the jury. Mr. Ray did not plan the death of his child. And the state, they didn't prove he did. They didn't prove he did willfully, deliberately, nor intentionally. And for that reason, you must find him not guilty. Thank you.
Thank you, Ms. McCormick. Mr. Aurora, rebuttal?
Yes, Your Honor. May I proceed?
Yes, please.
Evidence, not emotion. That's what the defense just told you. For 10 minutes, they told you to look at the evidence. And members of the jury, I'll walk you through the evidence. Well, let's take a look at the evidence together. We have the spilled juice, the broken laptop, and the belt. We have the search histories. We have the large garbage bags, the bloody shovel, the bleach from the defendant's car. And we have Nathan's body itself. That is evidence. The defense just told you that this was a charge of impulse. And they're right, it was. The defendant got mad. He got mad because his son, Nathan, did something so simple, a spilling juice. It was an impulse. The defendant got mad and wanted to punish Nathan, and that's exactly what he did. I want to clarify one more thing, members of the jury. I want to clarify the law. Defense came up here and they told you a lot about premeditation. But before you go back and deliberate, Judge Spurbar will read to you the jury instructions. It says that malice of forethought may be proven by showing a killing was premeditated, but it doesn't have to be proven that way. It says verbatim, to kill with malice of forethought means either to kill a person willfully, deliberately, or intentionally. It says to kill a person intentionally. That is malice of forethought. We know everything, every single thing the defendant did today was intentional. He intentionally tied that belt around Nathan's neck. He intentionally pulled that belt as hard as he could until Nathan couldn't breathe. And he pulled that belt intentionally as hard as he could until Nathan was dead. The defense contradicted themselves because they told you this case about evidence, not emotion, but they're ignoring the evidence. They brought up that the defendant had hallucinations, that delusions, but this isn't evidence. The evidence, the objective findings show you that over the course of 8 years, countless doctor visits, 2 full mental health examinations, no one, no coworker, no family member, no doctor, not the defendant himself mentioned hallucinations. These only came up when the defendant was being arrested. Now, even if you find that the defendant has schizophrenia, even if you find that he isn't lying, you can still find him guilty if you find that he knew right from wrong. Dr. Legrecker told us that when someone hides evidence, they know right from wrong. Dr. Legrecker told us that when someone doesn't deny their wrongful actions, they know right from wrong. And both of these things happened in today's case, members of the jury. We know he hid evidence. We know that the defendant tried to justify his actions. We have met our burden. The defendant murdered his son, and he's trying to get away with it. Don't let him. Find the defendant guilty of first-degree murder.
Thank you, Mr. Aurora. Now, before we do anything else, let me impart on the jurors that as soon as you possibly can, but don't rush it, obviously, get it right. But let's get those score sheets in. And then once we get the score sheets in, then we can, move on to some very brief comments. I know that, it's late and you guys probably want to get off of here and get moving on to closing ceremonies. So, just let me know, guys, jurors, when you've submitted your forms, and once we have the okay from, Phil and crew, then we can go on. Thanks. guess while we're still submitting score sheets, I'm going to ask the jurors to stay muted until we get the okay from Phil, etc. But at least I think I can say fantastic job. That was a really enjoyable trial to watch. It was clean, it was quick, it was smart. There wasn't really a lot of objectionable stuff, which is why there weren't a lot of objections. So that was pretty cool. I anticipated there to be a Pasquarello fight. I think every one of these rounds should have a weird Pasquarello fight. I don't know if everybody comes out on it the same way that I do. It's tricky, and I think that's one of those things where there's something to be there's a lot to go with off that. But anyway, yeah, I just wanted to say great job. I probably shouldn't say anything more while we still have ballots outstanding, though. So, but thanks for a good trial. Just like before, we're still waiting on one score sheet. So again, if you guys don't want to have your cameras on, you don't have to. So you can roll your eyes or whatever with the cameras off. It's up to you, and I'll come back when it's time for comments. Okay, so we got the all clear. We are CR7, right? Yeah, we are. So anyway, as I was saying before, seriously, you guys did a fantastic job. I was impressed. I think everybody would agree that that was a fun one to watch. You know, as far as my rulings went, I tried to be kind of deferential here and there. The Pasquarello thing I think is weird, so I kind of welcomed the debate on that, and I'm glad that I think that we came to an interesting end on it. But anyway, for the sake of getting y'all all logged off so we can get on with the award ceremonies and stuff, I think I'm going to turn it over to the jurors for their brief comments. So jurors, I think that this has probably been covered already, but because I think they've already pushed back the award ceremony once. So if we could stick to maybe like 1 or 2 brief comments, that would be great. Since I see Juror Johnson on the screen, you want to go first, and then we'll move through from there.
This is Tom Johnson. I'm a retired assistant U.S. attorney, but my claim to fame is I was the high school mock trial coach for Phil Pasquarello. I want to tell you that this was an excellent trial, but I think the high point for me was the direct and cross-examination of the defense expert. I think the direct of that was fantastic, had me completely moved in the defense side, and then the prosecution brought me right back on their cross. I think both sides did an outstanding job on that, and the scores that I gave will reflect that. Thanks.
Thank you very much, Tom. Let's do Juror Newman next.
Hey everybody, my name is Josh Newman. I'm an attorney here in Philadelphia. I do pharmaceutical litigation, mass tort. I thought everyone did an amazing job. I mean, clearly you all prepared a ton. I mean, that was insane. I thought it was very, very, very well done. And Sir John, I thought that your cross-examination was incredible. That probably flipped me away from the NGRI defense completely. I was like totally on board with that, and then you flipped me. So, pretty much everyone overall, great comments, excellent job.
Okay, thank you. And last juror, Mr. Spanos.
Hi, everyone. Great job with this. I'm a former prosecutor, and now I'm in-house for a food service company, and I also coach at Drexel. I thought this was a trial that was excellent, and it got better as it went. I think it really, for me, came down to a showdown between the closers. So you both did excellent jobs, particularly like Ms. McCormick, just the use of technology, especially in this Zoom era, and following along. I just felt that was an effective way. And I would just say, great job. And certainly tone and tempo during crosses can make or break it for me. And that was something I just want you to know in terms of my factors, that kind of control, and also facial expressions when things weren't going your ways. Those were things that mattered to me. But overall, great job, everyone.
Okay, I think that's everybody. In the interests of moving things along, I think we'll call it a night. But it's been a pleasure. So thank you all for I hope you had fun. I had fun watching. And we'll see each other at the awards.
Thank you.